make pleasure lawsuits. Let the matter be listed on Friday, my lord. I have filed on 18th 8 2025.
Tuesday?
Friday.
Any urgency?
Yes, my lord, because in law court it was fixed on Wednesday. That's why we have to appear before the court. That is why
Tuesday then?
Tuesday, next Tuesday. Lies.
Please proceed item 28 with our
Item number
28.
28. Yes.
On the other side, my lord, we need some time to file our objection in IA.
In the IA. Okay. You are Mr.
Yeah, ma'am.
A. Ahmed. IA is for what?
Imprisonment.
Okay. Mr. K. Ahmed, Learned Counsel for the opposite party in IA Criminal
5th of September.
839/2025 has paid for a week's time to file an objection. So as the prayer is stated to be made with the consent of the learned counsel for the applicant, the prayer is allowed. Raise the case after a week on a date to be fixed by the office.
September, ma'am.
I have to mention item number 22, Lordship.
20?
22. This is a division bench matter, Lordship. The sentence has been awarded 20 years. But
We'll see at the time. We'll
Lordship,
see at the time when the case is taken up.
I will go to medical for check-up, Lordship.
Okay,
So
we'll look into it. Mr. Kosik will look into
I
it.
have already informed them.
We'll record your presence.
Yeah, they IA one. It was last posted on
Okay. Next week?
Tuesday. Ma'am.
Next week. No, not Tuesday. Oh, we have posted many matters. What is the urgency?
Connected with petition. No, Tuesday.
Connected read petition.
Connected with that is petition.
Okay.
If I may, my lord, I beg to mention item 17 of the daily list today.
17.
Yes, my lord.
Okay.
My lord may fix it after a week, my lord.
Okay. On the prayer of Mr.
G. Imtiaz, my lord.
J. Imtiaz,
On behalf of Mr. S. Ali.
Learned Counsel appearing for a petitioner, list the case after a week on a date to be fixed by the office.
Deeply obliged. ma'am.
I have been. I have to mention what about IA, sir?
30.
30. So I have been appointed as an advocate in law. I need some time to file my objection. I have informed the other side.
Okay. Mr.
A Mena Laws.
Amicus Curiae for the app, response number 2 has paid for a week's time.
3 weeks.
3 weeks.
I think the volume is recorded.
This is I only.
IA.
3 weeks time to file an objection to the application seeking suspension of execution of sentence. First of, it is stated that consent has been taken from the learned counsel for the applicant to make the prayer. The prayer is allowed to release the case after 3 weeks.
May I please, your lordship? Lordship, I beg to mention item number 12, my lord. My lord, matter will come after 1 week, my lord.
Okay, on the prayer of
B.
Mr.
Soikya, my lord. B. Soikya.
B. Soikia, learned counsel for the petitioner, release the case after a week on a date to be fixed by the office.
Much obliged.
Maybe the subject to mention for Withdrawal matter.
Okay.
May I please, your lordship, I beg to mention for item number 38, your lordship.
38.
38, your lordship.
Yes.
Yes, sir. Lordship, Learned Counsel UK Burman's paternal uncle expired, your lordship, so he couldn't come today, your lordship. So,
Mr.
R. Kumar, your lordship.
R. Core learned counsel for the appellant has made a prayer for adjournment on the ground that leading counsel, Mr. UK Burman, is in bereavement. Mustafa has sought for release the case after
1 week, your lordship, on September
after 1 week,
1st
on a
or
date
2nd, your
to by
lordship.
the office.
Date may be given, your lordship. It is fixed for
Sure.
orders, your lordship.
Office not by, I don't know, after a week.
The lodge.
Yes.
This is the lodge. Of the
No, what are the other cases? Right, other cases are in motion. Huh? When it is, they are listed. We can, you get it listed, but we can post it on fixed date, next Wednesday. We don't know what is the condition of the other cases. We can post these cases on next Wednesday. As Nazdin, on the prayer of Ms. S. Nazdin, Land Council put a petitioner, list the case on Wednesday, same 6. You make it listed.
I
But Tuesday not, already many matters. Some other day, give it to the court master.
May I please, your Lordship? Lordship, I beg to mention for listing one criminal revision petition, Lordship. Any date, Lordship.
Or
For admission, Lordship.
give it to the court master.
Another Lordship
May
for
I-
withdrawal, Lordship. Tomorrow, Lordship.
Your Lordship, but I beg to mention for listing a criminal revision petition on 27 Lord, for motion Lord.
Why 27 is important? Okay,
Obliging.
Please, your Lordship, also I beg to mention item number 3, Lordship. Lordship, kindly pass over the matter for the day.
on the prayer of
NJ Begum.
AMJ Begum Land Council. How many adjournment? Let us see. In the motion column.
Lordship, I am on behalf of Mr. S.H. Sigdar, Lordship. And he's today out of station and letter of absence is there, Lordship.
Already 3.
So kindly last chance may be given. Only,
Otherwise, I will dismiss it for non-prosecution.
only for the day, Lordship.
On the prayer of Miss
NJ Begum, Lordship.
AMJ Begum Land Council for the petitioner. List the case on next Tuesday.
I beg to mention. for-
Bless.
As already 3 adjournments have been sought.
for listing. Criminal appeal.
Appeal for admission. Okay.
May I please, your Lordship? Lordship, I beg to mention item number 44 of supplementary, my lord. My lord, my senior is now out of station, my lord.
Hmm?
My senior is now out of station. So
Okay, on the prayer of Mr.
R.I. Bhuya.
Arabia Land Council for the petitioner. This is passed over for the day. R. MP Goswami, present. Yes.
Listing Your Honor. May it be listed tomorrow, Your Honor.
No.
Your Honor, the trial court is listed day after tomorrow.
Not at the last moment, don't make such mention. Next week.
May it please, your Lordship, also I beg to mention for listing of a criminal revision petition for orders and criminal petition for admission for Lordship.
Admission column.
next
Okay. Next week.
Your Lordship. Lordship, I beg to mention for listing of an IA, Lordship. In connection with criminal appeal, Lordship.
Okay, give it to the court master.
Lordship, deeply honored. May I please, your Lordship? I beg to mention for listing of criminal petition, Lordship.
Criminal petition.
Criminal petition.
For what?
Lordship, NBW issue against him, Lordship.
Give it to the court master next week.
Daily list for withdrawal, item 1.
Oblige.
Please, your Lordships. The matter pending before the learned trial court has been disposed of, Lordship.
Dispose of.
He has
Okay,
disposed of.
Mr.
So I may be allowed to withdraw this. petition.
Zaid Hussain, Land Council for the petitioner, has submitted that the proceedings before the land trial court has already been disposed of. And as such, the subject matter of the instant criminal petition has become infractious. Full stop. In view of such submission made by land, PP is present, huh? Made by Mr. Hussain, Land Council for the petition, that criminal petition is dismissed as not placed.
Yes, sir. Item 2.
Item 2.
Yes,
Same
Lordship.
thing.
In this case, actually the matter has been settled in between the parties, Lordship, husband and wife.
Okay. Mr. J. Hussain, Land Council for the petition, has submitted that during the pendency of the instant criminal revision petition, the matter has been amicably settled between the parties, and therefore, the revision petitioner is not interested to pursue the instant criminal revision petition. Full stop. Goswami present. Who is in attendance? Mr. MP Goswami, Learned additional public prosecutor, who is in attendance, has submitted that state has no objection to the above prayer. In view of the above submission made by Mr. Hussain, learned counsel for the petition, the criminal revision petition is closed.
Deeply aligned. For motion, item number 4.
May it please your lordship.
Yes.
My lord, the order which has been impugned in this petition that your lordship will, my lord, find at page 373. By that order, my lord, the application of the my lord, police for taking away one document for sending it to FSL has been allowed, my lord. Notwithstanding the fact that, my lord, the same document was twice sent to the Forensic Science Laboratory, and my lord, the signature of the petitioner, the person there was confirmed. My lord, first, let me take your lordship to the impugned order. Thereafter, I'll, my lord, give a little background, my lord, why the petitioners are aggrieved. Page 373.
Yes.
May I read it, my lord? This application was filed, my lord, on an off date, and the order was also passed on an off date. Although the, my lord, the petitioner, your lordship, my lord, they appeared, and my lord, the matter is proceeding. In spite of that, my lord, on an off date, this was filed, and off date, my lord, this order was passed. Seer put up today, since the prayer of the OC, Morigaon Police Station, Sri Bhaskar Burman, stating that the original copy of the status report submitted by the District Elementary Education Officer, Morigaon, white memo number such and such dated 21/2/2014, is required for further investigation of the case. In the petition, the OC Morigaon has stated that the then DC Morigaon had already made a fact-finding inquiry through a 3-member committee, wherein it was found that the appointments of the 29 number of teachers were fake. The then DEO, Abdul Razzaq, was also of the opinion that the alleged appointments were fake. Accordingly, he lodged an FIR before Morigaon PS with a request to investigate into the matter. However, surprisingly, when the Director Elementary Education sought for a report from the then DEO Abdul Razzaq, he submitted a report that the similarly situated teachers in other schools have been regularly getting salary, and as such, the alleged 29 teachers should also be entitled to regular salary. The petitioners are among those, my lord, 29. The report submitted by the then DEO Abdul Razzaq is not only denied by him, but also incompatible to the findings of the inquiry conducted by the DC Morigaon, the investigation in the instant case, and the stand taken by the then DEO Abdul Razzaq himself. The OC Morigaon has stated in the application that the report of the FSL Kahilipara, Assam, does not reflect the true fact of the matter. This is, my lord, absolutely wrong. I'll show, my lord. And as such, it is necessary to get it further examined by CFSL Chandigarh to bring out the actual truth. Learned additional PP has submitted that the whole allegation pertains to a scam of illegal appointment of the teachers, which has direct implication on the exchequer of the government, as well as morale of the public, and any lacuna in the investigation would not only benefit the accused persons, but also send a wrong message to the society. The learned additional PP submitted that in the interest of justice, it is necessary to ascertain whether the signature of the District Elementary Education Officer put on 21/2/2014 while submitting a report to the Director of Elementary Education, Assam Kahilipara, was genuine or not, in view of the fact that came out during the investigation of the case. Accordingly, the learned additional PP has prayed for allowing the original copy of the status report for further scientific investigation. In the light of the contents of the petition, I have perused the alleged inquiry report conducted at the behest of the DC Morigaon, 161 statements and the FIR. I have also considered the submission made by the additional PP. I am of the considered opinion that in the interest of justice and investigation, there is no bar in allowing the investigating officer to ascertain the genuineness of the signature appearing in the status report as mentioned above. Hence, prayer is allowed let the original copy of the status report submitted by memo dated 21/2/2014 is allowed to be taken by the OC Morigaon, Sri Bhaskar Burman, keeping a proof in original copy of the same with the record with the direction to submit the same as soon as the necessary investigation is completed. Now, my lord, this order has been passed on the basis of the application that was filed, my lord, because your lordship has seen that it has been stated that, my lord, the report was not, my lord, clear. Oh, no, not to change the fact that, my lord, it was sent to the FSL twice. And, my lord, it was proved, my lord, the report of the FSL clearly says that it is the signature of Abdul Razak. So for the third time, my lord, they are sending it. Now, my lord, how the court has been misled in passing this order, the application your lordship will find, my lord, at page 371. 370, well, I'm sorry, 370.
Yes.
To the Honorable Chief Judicial Magistrate, this is filed by the, my lord, Inspector of Police, that Bhaskar Burman. Reference so and so, prayer for providing the original copy of the status report, white memo number such and such, dated 21/2/2014 of the Office of the District Elementary Education Officer. Sir, with reference to the subject cited above, I have the honor to report that in connection with the fake appointment of 29 teachers, the then Deputy Commissioner Morigaon constituted a 3-member committee to inquire into the matter of fake appointments of the 29 teachers. After conducting inquiry to the matter, the committee submitted the report wherein it was found that the appointments were fake. Then the Deputy Commissioner Morigaon submitted the inquiry report to the Director Elementary Education Assam, Kahilipara, Guwahati 19. Thereafter, the Director of Elementary Education Assam asked the DEO Morigaon to submit a status report of the accused persons. Accordingly, a status report was submitted to the Director of Elementary Education Assam, Kahilipara, Guwahati in the name of the then DEO Morigaon, Mohammed Abdul Razak. However, on perusal of the report, it appears that the same is not compatible with the results regarding, my lord, inquiry conducted by the DC Morigaon, investigation made by the IO of this case, and stand taken by the DO Abdul Razak himself that the appointments were fake. It is also stated that the then DO Morigaon, Abdul Razak himself has filed the FIR alleging fake appointments. Under such circumstances, the report of FSL Kahilipara does not reflect the actual fact of the matter. As such, it is highly necessary to further examine the alleged signature of the then DO Abdul Razak through CFSL Chandigarh to bring out the actual truth. The informant Abdul Razak stated that he has not signed the status report which was submitted to the Director of Elementary Education Kahilipara, Assam, and he also stated that the accused person submitted the status report in the name of the DEO Morigaon, the informant, by number such and such dated 21/2/2014, which was false and forged, and the same is manufactured for their personal benefits. Now, my lord, this paragraph is important. During investigation, the original status report was sent to the Director of Forensic Science Laboratory, Kahilipara, Assam, for comparison with the signatures of the informant Abdul Razak. The FSL report was also collected from the Director of Forensic Science Laboratory, Assam, Kahilipara. However, the scientific officer could not clarify his opinion in the FSL report. This is, my lord, absolutely incorrect, my lord. The two FSL reports, my lord, your lordship will find it 368 and 366. If your lordship, my lord, kindly comes to the next page at 371, my lord. This is the, my lord, concerned letter, that status report. This was written by Abdul Razak, the informant now, to the director. This was, my lord, 21/2/2014, the original of which is now, my lord, sought to be sent to Chandigarh. Now, your lordship may kindly come to next page 372. There your lordship will find, my lord. Last paragraph, my lord. The above circumstances in the petitioners have been working in their post till date. The matter of the petitioners may also be considered separately. That was, my lord. Your Lordship will kindly see the seal of the, my Lord, Directorate of Forensic Science. That is, my Lord, that report is at page 368. And my Lord, another seal, my Lord, down below, Director of Forensic Science, dated, my Lord, number 258 of 2024. This Your Lordship will get it, page 366. And from, if Your Lordship kindly peruses these two orders, my Lord, these two, my Lord, reports, the fact will be clear that, my Lord, how the court has been misled. May I take Your Lordship to, my Lord, page 366? This report is of, my Lord, 31st of August 2024. This is the second FSL report, my Lord. The first also Your Lordship will see. Now, my Lord, the standards have been stated. The results of laboratory examination, may I read that, my Lord, down below? The document in connection with Morigaon PS case number such and such have been carefully and thoroughly examined and compared the disputed signature with the supplied standard signature in all aspects of the handwriting identification and the direction of the detection of forgery with necessary scientific aids like so and so, so and so. The person who wrote the blue enclosed signatures stamped and marked A1 and A2 also wrote the red enclosed signatures stamped and marked Q1 to Q9. The, my Lord, reference that has been given, my Lord, the description of the exhibits, these are the, my Lord, the Q1 to Q9, Your Lordship will find, my Lord. These are the, my Lord, original regulation orders. I will come to that, my Lord. So this is one report which has clearly stated Q1 and, my Lord, yes, serial number 3 is, my Lord, last my Lord, paragraph of that, my Lord, report at that piece, serial number 3, my Lord. The inter se comparison between the red enclosed signatures stamped and marked as Q1 and P1, P2 reveals similarities in their general as well as individual writing characteristics, thereby indicating that they are written one and the same person. That is, my Lord, Abdul Razzaq. Q1, my Lord, at top, my Lord, that is the report. Reference has been given, my Lord, 21 to 2014. And the others are, my Lord, the samples. So, my Lord, this is one report. The other report, Your Lordship will find, the first report at, my Lord, 368. Your Lordship, my Lord, I have shown the numbers. Your reference number, Your Lordship will find DFT QSD 385/17. Second paragraph, my Lord. The person who wrote the blue enclosed writings and signatures stamped and marked as S1 to SE and M1 to A31 also wrote the red enclosed signatures similarly stamped and marked as Q1. And Q1 is that, my Lord, Your Lordship has just seen. Now, my Lord, there are two reports which have already been given by the, my Lord, the FSL, and that clearly states that, my Lord, it is the signature of the same person. So, in spite of this, my Lord, now by misleading, my Lord, filing a misleading application, they have said that, my Lord, there is no conclusive finding of the FSL. It has been sent. My Lord, I'd like to give, if Your Lordship kindly permits, my Lord, what is the main matter about, my Lord, because it has been stated about, my Lord, appointment, fake appointments. Now, my Lord, these persons, my Lord, you listed this motion given. They were, my Lord, teachers, they were appointed in, my Lord, 1999. They were appointed between 96 and 98, my Lord, in the schools, my Lord, which are already provincialized. That is, there, my Lord, lies the my Lord, issue. They were appointed in provincialized schools by the managing committee. Then, my Lord, subsequently, they were regularized in 1999. After that, my Lord, since they were not getting salary, they approached this honorable court that our salaries should be released. because my lord, regulation was never an issue. Regulation orders are there, and those are also, my lord, not challenged anywhere. Then, my lord, this honorable court, my lord, the coordinate bench, my lord, had passed an order directing that, my lord, their salaries should be released. At that time, my lord, the affidavits were filed, my lord. All the questions, my lord, that were raised, my lord, those are answered. It's a very elaborate, my lord, order. My lord, I'll not take your lordship on that, my lord. But the fact remains that, my lord, there was a direction that their salaries should be released. Then, my lord, a review application was filed by the state. Now, my lord, when this writ petition was filed, and this particular document, my lord, was never, my lord, the petitioners never relied on that particular document, which is now being tried to be sent, and my lord relied on again and again. Now, my lord, after the writ petition was filed, my lord, then this FIR was filed.
Where is the FIR?
My lord, after the writ petition was allowed, my lord. Writ petition allowed directing, my lord, the salaries should be paid. Then, my lord, this FIR was filed, and my lord, the review was filed. The review was rejected by this honorable
Where is
court.
the FIR?
FIR, your lordship will 107, my lord.
107.
Now, my lord, your date will be important, my lord.
1 minute.
My lord, the date of the judgment in WPC 268 of 2013, my lord, where, my lord, there was a direction to pay the salaries.
Okay. Now, where is the FIR?
FIR is at, my lord, page 107. This was filed after the, my lord, writ petition was allowed. May I read it, my lord?
Yes.
With due respect, I beg to state that I am presently holding the post of Deputy Director, Elementary Education, Assam, Kahilipara, Guwahati 19. I have served as DEO Morigaon with effect from 28/1/2011 to 27/2/2014 and transferred to Golpara district as DEO Golpara. The above named accused are appointed by the managing committee of the different UP schools under Morigaon district during the period from 1996 to 1998 at a time when the said school had already been provincialized. Be it mentioned that herein that the period is claimed by the accused themselves. The order of regularization of the service of the accused are false and forced. This is for the first time, my lord. A plea was taken that it is forced, my lord. That was not taken in the writ petition in the affidavits, my lord. The then Deputy Commissioner Morigaon constituted a 3-member committee with Srimoti so-and-so, ADC, Morigaon, and the DEO Morigaon, the informant, and Madhav Malakar, the then Treasury Officer Morigaon, to inquire the matter of appointment of the accused and to submit the report to him. The committee inquired the matter and submitted the report to him. The then Deputy Commissioner Morigaon submitted the report to District Director of Elementary Education, Assam, Kahilipara, Guwahati 19, with letter number such and such, dated 25/2013. The Director of Elementary Education, Assam, asked the DEO Morigaon to submit a status report on the accused with letter number such and such, dated 13/2014. The accused submitted a status report in the name of the DEO Morigaon, the informant, with number such and such, dated 21/2014. This is the report, my lord, in question.
So,
In connection with
what
the-
has happened to this
My lord?
investigation?
This investigation, my lord, culminated into final report.
Okay.
Thereafter, my lord, an application was filed for further investigation. Re-investigation, the court allowed, my lord, further investigation. Then, my lord, the charges had been filed again, my lord.
How, if it is the final report was accepted?
Yes, my lord. That
Or
was
denied?
accepted and that was recorded in the, my lord, as I said, my lord, there was a
After
review.
If it is accepted, then there cannot be.
No, further investigation was
Where
done.
is the order?
Further investigation. Page 218, my lord, there an application was filed.
2-1.
An order was passed, my lord. 221 is the, my lord, the order that has been passed. But my lord, before that, my lord, I'll just, my lord, if your lordship kindly bear with me, my lord. The writ petition was allowed, then my lord, review was, my lord, dismissed. Or by, then my lord, the state went on writ appeal was dismissed, the matter was, my lord, taken to the Supreme Court, the SRP was dismissed.
Right, but what is the criminal proceeding?
My lord, in the criminal proceeding,
Let
my
me be
lord,
clear about the criminal proceeding.
my lord,
Then after final report, what happened?
my lord, the order that has been passed, order to 2182, this is the application. This is the application at page 218, my lord. Last paragraph, in this regard, it is to be mentioned that in reference number so and so, others, a special petition has already been filed before the Supreme Court of India bearing number so and so. And my lord, they prayed for, my lord, re-investigation. Then the ground taken was that, my lord, perhaps the earlier samples were not correct. And then, my lord, the second report of FSL came. Order
To honor to report.
221 is the order, my lord.
This 220 is the application.
218 is in application, is the application, my lord.
I will honor to report.
221 is the order passed.
Was registered with so and so. During investigation, was submitted in final report. Now, the complaining party submitted a petition for several points further examination in investigation. As there is further evidence available and examination of witnesses, it is prayed. Now, where is the order for page 221?
Operative part at 226, my lord. It's a long order.
So you were called for at the time. You were called for.
Yes,
page
my lord.
221.
Yes, my lord.
Submitted your
In fact,
written
my lord,
objection.
we appeared, my lord. Yes.
Rejecting the prayer on the ground that earlier.
The effective part is, my lord.
Was submitted after acceptance of so and so. Right?
Against this, my lord, the quashing petition is pending, my lord.
Okay. Into the so and so.
Part of.
So it looks like, I don't know what is the total content, entire content, but it looks like that impliedly the final report was not accepted and directed for further investigation.
Final report is accepted, my lord.
Where is
That
that?
has been recorded in the, my lord, order of the division bench also.
Where is that?
My lord, if I may take my final report of my next question. here.
Basically, it is an order whereby it is accepted. Division bench might have, I don't know, but where is the order of the criminal court? That final report is accepted.
That has not been annexed one, but I can produce it, my lord. And that was recorded in the, my lord,
You need to
division
state
bench
the
order.
proceedings of. Now, what is this complaint case?
My lord,
Come to 226.
my lord. They also
Give me-
filed
what
a
is
complaint case, my lord.
What is that?
Attack.
No, what is that?
That complaint case, my lord. It was the original. That's
No, what is that complaint?
similar allegation, same allegation.
Who?
Because the education.
Who is the
department-
complainant?
Education department. They will file the complaint case as well as the further investigation application. The courts take the complaint case, but allow the further investigation.
So meaning thereby there was no, impliedly final report was not accepted.
So that was their complaint.
Because this order of stay is under section 210
Yes.
CrPC.
Madam.
If on the same facts, one complaint case and one police investigation are ongoing, then
Then
in
what-
that
what-
case, the complaint case is to be stayed,
Yes.
meaning thereby the other case is live. And
that-
impliedly,
in
the
fact-
final report was not accepted. If it is,
No, in
final report is not accepted,
In
then
fact-
only under section 173, subsection 8, further investigation can be directed.
your lordship is right, my lord.
Perhaps.
Yes, and that's the ground, my lord, on that
Right.
ground, we have filed the, my lord. quashing
Right. What
application.
had happened? Any stay?
In the, my lord. quashing-
Email petition.
No, there is no stay.
I-
Then, my lord, charge sheet has come. Your lordship will may kindly peruse this charge. sheet.
Charge sheet.
Yes.
Where is that?
In this case, my lord.
Where is that?
It starts at, the
Two,
it starts at page 284.
284.
Yes, my
starts.
So, this order was in challenge. This page, this one, 220, 221, order dated 14/6/2024
yes, my lord.
is in challenge
Yes, my lord.
in criminal petition.
That is, that in a separate petition.
No, that is not state.
Yes,
That is not,
not state.
no interim order.
No, no.
Then charge sheet was submitted when?
Yes, ma'am.
Page?
284, my lord. It starts at 284.
284. That was submitted on 7/9/2024.
Yes.
And how many have been charge sheeted? All these petitioners have been charge sheeted.
Yes, my lord.
Along with Abdul Razak,
No,
or no? No.
no, Abdul Razak is the informant. He has not been charged.
Sometimes it happens.
No, earlier,
Informant is made a
no,
excuse of.
earlier FIR the police say that he has filed a false case. Anyway, that is.
And after submission of charge sheet, what has happened? That is
357.
420, 167, 177, 467, 468, 4.
The relevant part will be, my lord, your lordship, it's a long report, my lord.
Now the question is, maybe
My lord.
everything hinges on that page 370. Last but one para, that however the scientific officer could not clarify his opinion in the FSL report.
That is wrong, my lord.
That is, yes.
That is absolutely wrong, my lord. I have shown the two reports.
Hmm.
And my lord, the first thing, my lord, otherwise my lord, appears to be a very innocuous order. But the fact remains, my lord, what is the reason why you file it? We have already appeared in the case. Why do you file it on an off day and thereafter pass the order on an off date, my lord? If your lordship kindly, my lord, if I may, my lord, bother your lordship, 357, my lord, page 357, that is a part of the charge sheet.
Yes, Mr. Usman.
Lordship, I've seen
My
that,
lord,
but
I'm,
that's been
just
stated, my lord.
one moment, my lord, I am not asking for stay of the proceeding, my lord. What I am on this is on against this order only.
Order as a genuine, you get a query. They will, because it's not as a, asked me.
In the, my lord, charge sheet, even, my lord, they have admitted the regulation orders as, my lord, genuine.
Oh, we are not into it. We are into the nature of investigation, the process.
And in fact, your
In a charge sheet, is there any mention of the FSL report? Earlier too,
in this, my lord,
in the charge sheet. Because documents are to be relied upon. This Bapukon Chaudhary is,
charge sheet mention portion. That has been.
he is an witness.
Page 362, my lord.
That, my lord, page 367 and 368 that I had drawn your lordship attention to.
No, those are report.
Those are the part of
Those
the
are part of the investigation report.
Those are part of the
charge sheet.
report. If your lordship kindly
FSL.
comes to page 357. my lord.
FSL report.
চাকর রিপোর্ট এখন নকলে চুপচাপ থাকি বাট রেগুলেশন অর্ডার প্লাস এটা করে পেজ 2 357 of it
Question is, Mr. Goswami,
Lordship.
why this, what is this sentence?
Sentence, my lord.
Why he is expressing doubt or whatever,
Yes.
that scientific officer could not clarify his opinion in the FSL report? What does he mean? When there is existence of two FSL reports from handwriting expert, this copy can be taken out for some investigation, right?
Oh, that is,
right.
yeah,
But
cannot-
otherwise, but the
Only
next
the-
purpose, copy can be taken out with the permission of the
Yes.
court. For that, the accused leave is not required. But
Yes.
question is sending it the purpose
Yes.
behind taking out
Yes.
is that the scientific officer did not clarify.
No.
But it is clearly clarified, both the reports.
Yes, that is.
now, my lord,
My
they cannot.
lord, I cannot go to the all through the petition, my lord. So at least I have to go through all the petition once more, my lord. Regarding,
Otherwise, the question
I
is-
have seen what your lordship is indicating, my lord. I have understood. my lord.
Yes, the reason assigned for taking out the report
Yes.
is to send it to the
Yes.
CFSL for examination
Mm.
on the ground that
Yes, ma'am.
scientific officer
Yes.
of FSL Guwahati
Yes. Yes.
did not clarify.
Yes. That
But
is.
on perusal of the two reports,
It is-
there is no ambiguity.
Yes, it is otherwise.
Clarify his opinion in the FSL report.
Yes, it is otherwise. That is.
And he is a witness,
Yes.
listed witness.
Lordship. Yes.
That could have been done later on. Why?
Yes.
And the doubt arises, my lord, why on an off date you file it behind the back, my lord, so that we could not point it out before the my lord magistrate.
This I have no comments to make regarding that, my lord. Just I am praying for today itself only.
But
Yes.
even if it is a case,
Yes.
this opportunity should be given when they are facing the trial.
Yes.
Then if such a document is to be taken out for the purpose which has already been accomplished
Twice. Lots.
twice,
Lots.
at least they should have been given opportunity.
Yes, that party. That party. Yeah, well,
Find out, and if
Yes,
it is, go through the record.
Yes,
have
but
just
because it's
had the
also very
occasion to
well.
go through it.
Yes,
Uh,
several facts are there to be assessed.
But the question is hinges on that point.
Yes.
Did not clarify his opinion.
Yes.
That is too vague.
That is.
And there
observation-
is no discussion by the magistrate also.
Observation, my lord.
Region
Yes.
recorded
Yes.
for reaching the satisfaction.
Yes. ma'am.
Okay, allowing him to take out the document is okay.
Lots.
But the purpose
Lots.
is for sending it to CFSL.
Mhm.
But that has already been accomplished twice.
Lots.
That part,
Yes.
and without hearing the accused,
Yes.
and that might have escaped the notice of the court,
Lots.
right?
Lots.
Something might be escaping
Yes.
from my eye also, like that magistrate
Yes.
from this bulky
But
record,
that is what.
and he has all the search sheet and all the documents.
Lots.
Think it over,
Yes.
otherwise this might
Yes.
be vulnerable.
Lots.
I don't know. Okay, when do you want?
See, day after tomorrow. Or
Day after tomorrow. Friday.
as your lordships,
Yes, Friday.
My lord, no objection to that, but then, my lord, till that time, my lord, that is.
No,
Friday only.
Otherwise, my lord, they
I-
send it again, my lord. And
No,
what we-
it is the
what we
order is of,
apprehend-
your lordship will find
What
order
we
is of
apprehend is
13.
that, my lord, we do not know that may be manipulated because that particular document we had never, my lord, relied. That report came after we filed the, my lord, filed the, my lord, in the writ petition, we never, my lord, relied on that.
14-6 order, you have come here.
13-6
You
order
can wait 2 days.
to the 13th. That is what I am.
Okay.
Lordship.
We
No,
are, my lord,
please.
apprehending manipulation again, my lord. That's why, my lord.
Manipulation is not there.
We do not know, my lord, what will be
Uh,
documents sent now,
privacy-
my lord.
Privacy not there, but the question
Because
is
what? There is
maybe a high-handedness and
This entire exercise has been carried out because, my lord, there is a contempt pending against them for not releasing the, my lord, service role and, my lord, area service.
Listed by Mr. M. Dottal, Learned Counsel for the petitioners. Mr. M.P. Goswami, Learned Additional Public Prosecutor, has sought accommodation to make his submissions as sought for by Mr. Goswami. List the case on Friday.
Lordship.
22/8.
Consider on the date. Your lordship may kindly observe, my lord, interim prayer will be considered on that particular day.
We are not open anything. Will be open for everything.
Lordship.
Item number 7.
Now, please.
Wajid Nasir Ahmed. Yes, Mr. Chaudhary. What is the prayer here?
May I please, your lordship? Lordship, the
Understand you are
filed by
pleased to admit, call for record, impugn judgment and order. Principal Judge. Family court. No, if family court. Mr. Chaudhary,
Lordship.
criminal revision petition
Revision petition.
against the judgment.
Lordship.
Against the judgment.
Against the judgment, lordship, dated 2/4/2025.
Huh?
2/4/2025.
I have been receiving such. Please have this 19-1.
19.
এখন যে রোস্টার যখন থাকে যে এই রোস্টার যে সপ্তাহৰ মতে যে ওলায় তাতে কিন্তু লিখা থাকে কি কি থাকে।
Lordship. And lordship, may,
No, I am asking you,
lordship.
I have been receiving such kind of petition against the final order and
Lordship.
judgment of the family court. And that section is with a non-obstante clause,
Lordship.
notwithstanding anything in CrPC.
Lordship.
Final judgment not being an interlocutory order.
Lordship. This is final, lordship.
And our notification. There is one notification that if it is from family court, it is to be before division bench. And if it is from session judge,
Lordship.
then before single bench.
Single.
Notification. Because if we go on entertaining this,
I may be allowed to withdraw, lordship. And
no, let me. I am not
Lordship.
asking you. Let us have the notification.
Lordship.
On the basis of that,
Lordship.
because see, subsection 5 or subsection 6.
Five, lordship.
When I was sitting in division bench,
Lordship.
division bench was receiving,
Lordship.
and entertaining
Lordship,
appeal
Lordship,
against this kind of order from the family court.
Lordship.
Proceed.
An appeal preferred under subsection.
Just a minute. See, this, do you read this? This
No.
comes every week.
Lordship,
Special division means 2. Confirmation of decree of divorce
Lordship,
and such matrimonial appeals arising out of orders and judgments
judgments,
passed by family court.
Lordship,
On the other hand, civil and one. People ask their socks. I may not be correct.
Lordship,
Civil bench.
family court of consummated case. And then
Mr. Usami, any idea? Let us have that family court act again. Asani ki sabosun. Otherwise, we'll let them have a
Lordship,
verification. Thereafter, if we get the notification, okay, otherwise we'll take out after some time.
Lordship.
Huh? Oh, yes. Both of you read this one. Mr. Kosi, you also read. What can you make out from this? Or about 30 খন আছে নেকি? Impartial modification.
এখন লাগিব।
Two. No, here, because it says subsection 6, an appeal preferred under subsection 1 shall be heard by a bench consisting of 2 or more judges. And that notification. And this is a final order. Call for need proceedings in which family procedure. Okay, we'll issue notice at this stage.
Lordship.
We'll issue notice at this stage. Some confusion is there. Yes, what is your grievance?
Lordship, in this case, Lordship.
5,000.
5,000, Lordship.
You are what?
I'm the Lordship
Labor,
Lordship, part-time teacher, Lordship,
part-time teacher,
on monthly salary of 3,000, Lordship.
20,000.
3,000, Lordship.
3,000.
3,000, Lordship.
Teacher has more income than lawyers. Yes, we'll issue notice at this stage. Heard Mr. Ayush Chaudhary, Land Council for the petitioner, and MP Gusami, Land Additional Public Prosecutor for the respondent number 2, State of Assam, was of the instant criminal revision petition under section 438 and section 442, read with section 442 of the Bharatiya Nagorik Suraksha Honita 2023. Oh, section 438, section 442, read with section 53, is preferred to assail a judgment dated 2/4/2025, passed by the Court of Learned Principal Judge, Family Court, at Dhubri, Family Court, in FC within bracket CRL, case number 28 of 2024. Full stop. The respondent number 1 as the petitioner instituted FC criminal CRL case number 28/2024 under section 144 of the BNSS seeking maintenance from her husband, that is the petitioner hearing, posted by the judgment dated 2/4/2025, the family court has directed the petitioner to pay monthly maintenance amount of rupees 5,000 to the respondent number 1 hearing. Matter would require consideration. The scanned copies of issue notice returnable in 4 weeks. As Mr. Goswami, respondent number 2, petitioner to take steps, respondent number 1, both mode, register so and so, scanned copies of so and so. No, scanned copy, it is already disposed of. The case records of so and so case number be called for. These matters arising out of some 30 on. Bit confusing. Family court special division bench. And it is not an interlocutory order, final order.
Final order.
Because while I was sitting in division bench, I have been entertaining this kind of petition from family court, not district court. That is a single bench is also entertaining, division bench is also entertaining. The registry to look into the matter of listing of this kind of petition against a final order of the family court in terms of the notification, number 30 dated 22/5/2024, read with notification number 30 dated 21/3/2023.
Item number 8.
May I please, Your Worship? In this criminal revision petition, Your Worship, prefer for set and modification the impound order dated 1/7/2025. Pass in session trial case number 75 of 2025.
Sessions trial,
Yes, Your Worship. Impound order at page 18, Your Worship.
page 18.
Yes, Your Worship.
And what is the
Fact of the case is that, Your Lordship, the petitioner filed Zimmer petition for custody of 6th article before this,
what kind of article?
4 numbers of mobile and two
Mobile
vehicles.
phone and one vehicle
Two
also.
vehicles, Your Lordship.
Two
the-
vehicle.
Yes, Lordship. The Zimmer petition had been
And-
filed by the
Allowed with bank guarantee, that is what the lordship has entertained.
Okay.
Yes,
Okay.
that is, all cases are fixed on 21, my lord. Your
21.
Lordship has instructed us to, my lord.
Okay, we'll put it the case on 21.
Lordship. Coordinate,
Tomorrow.
Tomorrow, that is.
Okay, list the case tomorrow.
Lordship, can I place a coordinate order?
With region or without region?
Reason, your lordship, similar matter.
Offense is under what?
Cattle preservation. At least, the suspected cattle has been transported.
No, this is not the one. There is another one. Good one. Succeeded case.
Succeed.
Release the case tomorrow.
Item 9,
So, may I please, your lordship?
Yes, please.
Lordship, this is
Yes.
a charge sheeted case, lordship. The petitioner, there are two petitioner, lordship. Against both of them, lordship, they are declared, lordship, proclaim absconder, lordship. And NBW, Pending
Let us speak
NBW was
to
issued.
Romain Das
I guess. But
and
in-
Bijoy Das.
Yes, lordship.
Okay, let us see the FIR first. No FIR.
No, lordship, I have annexed the judgment, lordship.
Annex the judgment.
Judgment, lordship.
Judgment?
Because, lordship, there were 3 accused in total in this case, lordship. So 2 were not appearing. Therefore, lordship,
Okay, you have stated in your petition.
yes, lordship. 2 were not appearing, lordship. Therefore, against the 2 petitioners, lordship, the case is temporarily filed,
1
And-
minute, 1 minute.
lordship. And
One
accused
state
is
by
acquitted now.
Gugamuk station. Give us a minute.
the brief of the case, lordship, will find on page 25.1 of the judgment, lordship.
We are not concerned with the judgment. Now we want to take the benefit.
No, lordship.
Absolutely not. We are not entertaining this. You are taking the justice process for a ride. For last 4 or 5 years, since 2019.
Since,
One person, he appeared,
yes, lordship.
right? 2022.
Yes, lordship.
Thereafter, you are having no respect to the process of,
The conduct is admittedly, lordship.
absolutely, no.
Yes, lordship.
Leniency cannot be extended to such an extent.
Yes, lordship. Conduct is.
No, absolutely. Unpardonable. The court is waiting for 4 years. You appeared once. Thereafter, you vanished in thin air. Just when you got the news
Yes.
of acquittal. No, absolutely not.
Well.
We cannot extend the benefit to such an extent. Absolutely not. Must be tried, perhaps, within custody. Absolutely not. This is not the way.
Lordship,
No, no.
the conduct is, lordship.
Conduct is reprehensible. And you are keeping the court for last 4 years, waiting for you. Absolutely not. We cannot pass an order thereafter everybody will annex this kind of order.
No.
Absolutely not.
In the judgment,
So
Lordship,
similar order has been passed in similar writ petition, similarly situated. No, absolutely not. Hard, mister.
Lordship, kindly,
This is to be dismissed with cost. Reprehensible conduct scant respect to the judiciary,
that is admitted.
abusing the process of the court.
Admitted,
Hard,
Lord.
Mr. S. Hussain, learned counsel for the
Ke Thakur,
petition.
my. Ke Thakur, my.
K. Thakur.
Lordship, when direction may be given, I'll appear.
No, absolutely, dismiss.
And I may be allowed to withdraw, Lordship.
It is up to you. Absolutely no. Scant respect. I am recording it.
Lordship, I may be allowed to withdraw, Lordship. I may be allowed to.
No, no, after hearing that, I am not. Such leeway is not to be granted in such kind of case. Yes, Mr. Goswami.
Lordship, because that is what my,
The reason is apparent.
page
The
29.
reason is apparent.
Page 29, after acquittal,
And Mr. MP Goswami, learned additional public prosecutor for the respondent state. The two petitioners have approached this court by the instant criminal petition, seeking to invoke inherent jurisdiction of this court available under Section 528 of the Bharatiya Nagorik Suraksha Sanhita to assail two orders dated 6/5/2023
page 13, Lordship.
and dated 4/3/2024, passed
No,
during the course of proceedings of Sessions case number 70/2019 by the learned Session Judge Chubri. Full stop. Before, oh no, sorry, by the order. First order is at page
Lordship. Page, Lordship,
6/5/2023.
page 18, petitioner number 1, Lordship.
6/5/2023. Where is that?
Page 18, Lordship.
Why 6/5/2023 is before 2/2/2023? Huh?
Lordship, 6
Everything is not serial. By the order dated 6/5/2023, the trial court, the trial court.
Lordship, it is before because Lordship, it is in respect of petitioner number 2.
Roman Das, Digola Das. The petition number 1 by declaring the petition number 1 as an absconder, has decided to file the case against him for the time being. Full stop. By the subsequent order dated 4/3/2024.
Page 21, my lord.
Same. Petition number 2 লিখিব। Para. In order to appreciate the nature of challenge made in this criminal petition, it is necessary to narrate the relevant and necessary events leading to the passing of the said two orders. Post of para. It has emerged from the materials brought on record that against the two petitioners herein, along with another accused person, comma, a case, comma, Gogamukh Police Station case number 218/2019 was registered for commission of offences under section 120B 379 of the Indian Penal Code read with section 34 IPC. Post of. Upon completion of investigation, comma, a charge sheet under section 173(2) CrPC came to be laid by the IO of the case, finding primacy case against the three accused persons for offences under section 120B 450, 307, 323 IPC read with section 34 IPC. On submission of the charge sheet and after commitment, comma, the case has been registered as Sessions case number 70/2019. Full stop. Para. It is stated on behalf of the petitioners that I like it. I don't like it. In the after registration of the case, comma, the session case number so and so, comma, the petition number 2 and the other charge-sheeted accused person, comma, Srimati Bornali Begum Hunwal, appeared before the trial court on 25/11/2019 and filed a petition, comma, petition number 1794/2019 with a prayer to allow them to remain on previous bail post op. The trial court allowed the prayer made on behalf of the petition number 2 to remain on previous bail on 25/11/2019 post op. On 25/11/2019, comma, another petition was filed on behalf of the petition number 1. And the petition, comma, petition number 1793/2019 was filed on behalf of the petition number 1, showing his cause of absence. Showing cause of absence of his failure and prayed for fixation of another date. The said prayer made on behalf of the petitioner was also allowed, and the petition number 1 was allowed to remain on previous date bail till the next date, 22/01/2020. Full stop. On 22/01/2020, the petition number 1 the prayer made on behalf of the petitioner number 1 to allow him to remain on previous bail was allowed by the learned trial court. Full stop. The learned trial court on 22/01/2020 posted the case on 1/4/2020 for hearing stroke consideration of charge. Full stop. But it is true. It cannot be denied. No, this court is agreeable to the submission advanced by the on behalf of the petitioners that during the subsequent period, the court proceedings were affected due to emergence and continuation of COVID-19 pandemic. Full stop. Para. During the year 2000, on 27 to 2022, the other charge sheet accused person was found to be present, found to be absent, found to be present before the trial court. Whereas the two petitioners herein were found absent without taking any steps. Full stop. From the order dated 17 to 2022, it can be noticed that the trial court had ordered issuance of non-bailable warrant of arrest against both the petitioners. Full stop. Recording their absence on 17 to 2022, the trial court order for issuance of non-bailable warrant of arrest against both the petitioners. Full stop. Para. When it was split,
Page 20, my lord. 20, page 18 perhaps. 18. দুটা number আছে যে।
page?
18.
No,
18,
when
my
it was split, let us see the judgments.
Yes. Page 18, last part.
During the subsequent period, the trial court finding continuous absence of the petition, two petitioners from the absence of the two petitioners, decided to file the case against them and proceeded with a trial against the third accused person, namely, Muhammad Bornali Begum.
Bornali Begum. Sonowal.
Corneli Begum Hunwal. Full stop. তার একটু আগত ঠিক on 20/04/2022 the petition number 1 made an appearance before the trial court with a petition, petition number 600/2022 showing cause of absence on the previous date and made a prayer to allow him to remain on previous bail. Full stop. Allowing the said prayer, the trial court recall the non-bailable warrant of arrest. Full stop. On that day, sorry, Bijoy Das petition number 2. On that day, the petition number 1 was found absent without any steps, and the current court issued order for issuance of non-bailable warrant of arrest against him. Subsequent. During the subsequent, during the course of the proceedings in the subsequent period, the trial court ordered for issuance of proclamation against the two petitioners after finding, after reaching a satisfaction that the two accused persons are evading the process of the court stroke execution of the warrant of arrest. CrPC. After taking evidence as regards on the aspect of following the procedure followed for proclamation, publication of the proclamation and the reports of the EO regarding abscondence and non-traceability of the petitioners, the trial court by the orders, impugn herein, proceeded to declare the two petitioners as proclaimed persons. Poster. Para. From the materials on record, it has clearly emerged that the two petitioners initially responding to the process issued by the trial court, appeared before it on 25/11/2019. On prayers being made, both the petitioners were allowed to remain on previous bail. Full stop. Para. It has been averred by the petitioners that the petition number 1 was unable to appear before the learned trial court because he lost his communication with the previous engaged counsels, as he lost his mobile phone number, as he lost his mobile containing the mobile phone number of his engaged counsel. Full stop. As a result, he was not aware of the dates fixed by the learned trial court. Full stop. It is further averred that the petition number 1 was suffering from poor financial condition and for which he was unable to bear the cost to engage another counsel to know the present status of the case. Full stop. It is stated on behalf of the petition number 2 has averred that he was also unable to appear before the trial court because he also lost his communication with the previous engaged counsel after COVID-19 pandemic. And he was also unaware about issuance of MBW and proclamation and attachment order. Full stop. The petition number 2 has further averred that he was out of station for his work to meet the financial needs of his family, being as a sole breadwinner, and could not communicate with his engaged counsel. So as a result, he was unaware of the dates fixed by the trial court. Full stop. Para. It is interesting. It is relevant to note that the trial proceeded against the third seated accused person, namely Ms. Samad Bornali Begum Punwal, ended on 3/8/2024. As on that day, Command Trial Court had delivered its judgment against Muhammad so-and-so, acquitting her from the charges under Section 120B, 450, 307, 323, IPC, read with Section 34, IPC. Sorry, 307, 323, 34. Full stop. Para. As is evident, it is already evident that the two petitioners were aware of the proceedings of session case number so-and-so as far back as on 25/11/2019. Full stop. Despite being allowed to remain on previous bail, the two petitioners were absent on subsequent dates of hearing of sessions case number so-and-so for a period longer than 5 years. The reasons shown by the two petitioners are not fathomable for acceptance. Full stop. The conduct of the two petitioners have privacy demonstrated that they have scant respect to the process of the court and decided and have by flagrantly refusing to appear before the learned trial court for a period longer than 5 years, whereas the learned trial court has continued the proceeding, waiting for the appearance of the two petitioners for continuation of the trial for more than 5 years. Full stop. it is the fact of preferring the instant criminal petition after the acquittal of the third surseated, after the acquittal of the co-accused person on 30/3/2024 is a matter to be taken note of. First, as the two orders, SL hearing are found to be passed following the procedures laid down in the code. Agot code question hoy sake? Code question hoy agote? Dress code does not find any merit, any semblance or iota of merit in the instant criminal petition. First of all. Resultingly, the same is dismissed.
Chief, any direction?
Dismissed. You have to be taken into custody so that the trial can be proceeded. Maybe the result is acquittal, but for 5 years you have taken for a ride. Yes. And taken the judicial process for a ride.
Obliged.
Don't seek leniency from this court. Yes, sir.
Yes, my lord, on 13/7/2021, my lord, the petitioner appeared after getting summoned, my lord, and the learned court below allowed to go on bail, my lord. Allowed to go on bail, my lord. My lord, page 22.
Page 22.
Yes, my lord. 13/7/2021. Later on, bottom, my lord. Last line, allowed to go on bail or prove it so and so and so.
When?
My lord,
Similarly situated.
yes, my lord. I had my lord, item number 9. Subsequently, the petitioner could not appear, my lord. because-
Okay. COVID period we can understand.
Yes, my lord.
Same, you are not aware.
No, my lord.
You have lost contact with your engaged counsel.
No, my lord. I have stated.
Yes.
He is a daily laborer.
Orders galore.
Yes, my lord. He is a daily laborer, my lord, and.
Whatever. Taking for a ride.
Paragraph 4 and 5, my lord, I have stated. He was Hyderabad, my lord.
Whatever.
My lord.
Whatever.
My limited prayer, my lord.
Same.
My lord.
We cannot discriminate
My lord.
with similarly situated persons.
Petitioner, my lord, ready to
Right.
incorporate the trial, my lord, now.
You have heard the dictation
my
of the
lord, I
previous
have heard, my
order.
lord. Yes, my lord.
Same.
That is why, my lord, for limited
Same.
prayer, my lord.
How many occasions? 30, 40 occasions?
My lord,
You mean that judicial officer is sitting for
I am-
your appearance?
1, 2, 3.
Oh, 3/11/2021 to 18/6/2025.
11,
Could not appear
12
because you are in Hyderabad.
12 times, my lord.
Huh?
I have.
4 years.
4 years.
Yes, my lord, 12 times.
No.
My lord,
We allow genuine prayers.
my lord, my limited prayer, my lord.
Inexcusable. Same thing.
My lord, the petitioner ready to cooperate.
Not
my lord.
interested. We cannot extend to such. You are abusing the process. You appeared. Thereafter, you cannot take
Yes.
the plea. Right? Section 87.
But in this case, my lord, warrant of arrest has been. proposed.
Section 87.
87 is.
A court may, after so and so, if at such time, he fails to appear and the summons is proved to have been duly served in time to admit his appearing in accordance, there is no reasonable excuse is offered for such failure. Correct. We cannot recall. heard. You appear on your own, otherwise I'll pass the same kind of order. And we'll observe that 319 will operate. The court will exercise its jurisdiction by taking into custody. You can still make a prayer that is available. I'm giving you the option. On your own, if you appear, court will give. Otherwise, a copy of this order is to be sent to the court of science for information. I will did you about it.
Allow to withdraw, my lord.
You allow. I am not entered in. 2-3 dates, okay. For 4 years, court is sitting for you, and you are, after appearing, knowing fully well that you are part of the
Yes, my lord.
Yes.
My lord.
4 years. No. Heard Mr. M. Hussain, learned counsel for the petitioner, and Mr. R. Kosik, learned traditional public prosecutor for the respondent state post of. After hearing Mr. learned counsel for the petition at some length, Mr. Hussain has submitted that the petitioner wants to withdraw the writ petition in order to avail appropriate remedy. In view of the above submission made by Mr. Hussain, learned counsel for the petition, the criminal petition is dismissed on withdrawal in order to avail appropriate remedy before the learned trial court.
Obligation.
Item 11.
May please your lordship. My lord, this criminal petition is filed against.
Similarly situated or what?
My lord.
Huh?
My lord,
Let us see your order, impugned order.
Impugned order at page 42.
PS 42. Who are you?
Lord, I am the brother and father of the main accused. Is
Brother and Talha Raj Borbhia, Mayan Uddin Raj Borbhia. Okay, let's see page 42.
Petition number 1 is the brother-in-law of the informant.
Let us read page 42 together.
Page 42, my lord.
Accused
Tayyab
Tayyab
Raj
Ali
Borbhia
Borbhia is present.
Along with his learned and guest counsel. PW informant Shahina Parveen Borbhia is present. She is examined as PW1. Learned APP has filed a petition being number so-and-so under section 319 of CrPC to implicate Talha Raj Borbhia and Mr. Moinuddin Raj Borbhia as accused persons in this case. As PW1, informant revealed implicating materials against them and the investigating officer did not send him for trial. As such, the learned APP prayed to implicate Talha Raj Borbhia and Moinuddin Raj Borbhia as accused in this case under section 319 of CrPC. Had the learned APP who has fervently submitted that there are several incriminating materials against Talha Raj Borbhia and MD Moinuddin Raj Borbhia, and it is pertinent to add them as accused under section 319 of CrPC for a proper and fair adjudication of this case. Section 319 deals with the power of the court to proceed against any person or persons appearing to be guilty of such an offense for which the accused is prosecuted. This section talks about additional prosecution when during the trial it appears to the court that a person who has not been joined as accused in the case has committed the offense. Then in such a case, the person can be tried together with the accused. Coming to the matter in hand, upon going through the evidence on record, truly it appears that the prosecution witness who is the sole victim of this case has specifically stated incriminating materials against Talha Raj Borbhia and Moinuddin Raj Borbhia. Upon giving this matter due deliberation, this court is the opinion that it shall be the miscarriage of justice if Talha Raj Borbhia and Moinuddin Raj Borbhia are not implicated in this case as accused along with the present accused person. In view of the foregoing discussion, this court deems it fit to implicate Talha Raj Borbhia and Moinuddin Raj Borbhia as accused in this case by exercising the power of this court under section 319 of CrPC.
Where is the petition on the PP?
My lord,
Petition on the PP.
petition of the APP is not there, my lord.
Not annexed.
It is not annexed, my lord. My lord, may I come to the FIR, my lord? FIR at page 23, my lord. Relevant portion
23.
starts from 24. My lord,
23.
kindly peruse at page 31.
Okay. Page 23.
My lord,
How
page
do you talk?
24 is the relevant portion. It starts.
You were named in the FIR.
My lord,
You were named in the FIR.
my lord, my lord. My name is there in the FIR. Kindly see
It
page
is a
30.
complaint case or FIR?
It was FIR, my lord.
Okay, FIR.
It was FIR. Page 31, kindly see the bottom part. Date of FIR was 27/12/2017. It is relevant.
Page
therefore I am saying.
30,
Page 31,
17.
27/12/2017 is the date of FIR.
Yes.
The case was registered by police under section 498A, 307, 420 and 34 of IPC. Hereafter, my lord, after investigation, my lord, the police has filed charge sheet under section 498A against the husband only, that is Toyobraj Borguya, and the present petitioners who were released from the search, my lord. And accordingly, my lord, come to page 38. Page 30 is the search framing order, my lord. The learned court below, after hearing both sides, search were framed under section 498A of IPC. Thereafter, my lord, evidence stage has come at page 39, my lord.
PW1 was examined.
PW1, my lord. May I read?
Informant. Yes.
May I am the informant of this case. I lost this case against the accused persons Talha Borguya, Toyobraj Borguya, Moinuddin Raj Borguya, and Saleha Begum Raj Borguya. Saleha Begum is the mother, my lord. Today, on accused Toyobraj Borguya is present in the dock today. In the year 2015, my marriage was registered with the accused Toyobraj Borguya accordingly to Muslim law, and one Kabinnama was also prepared. At that time, I was student and staying at my parental house. The father of the accused, Moinuddin Raj Borguya, demanded valuable furniture and one Wagoner car. My lord, one Wagoner car was demanded. However, my parents were not agreed to the demand of the father of the accused, but ultimately one Wagoner car was given to the accused, Toyobraj Borguya. In the year 2016, after returning home from Saudi Arab, the accused Toyobraj Borguya, I went to my matrimonial house. Hereafter, the accused persons demanded rupees 50,000 in lieu of clothes as gifts for the relatives. Accordingly, I informed my mother about the demand of the accused persons, and my parents did not agree to the said demand. As a result of which, the accused persons started torturing me mentally. They also told me that if I had to stay there peacefully, I would have to fulfill all their demands. The father of the accused, Toyobraj Borguya, also forced me to transfer the ownership of his name of the plot of land measuring 3 kathas, which was in the name of my mother. My mother did not agree with the proposal of the transfer of the name in the name of the accused's father, but she agreed to transfer the property in my name. My mother also transferred the ownership of the said land in my name, and the accused's father was not at all happy with the transfer of the ownership, and he ousted me along with my husband, Toyobraj Borguya, from the house. Then we took shelter in a rented house at Panchayat Road, Silchar. Hereafter, the accused Toyobraj Borguya, along with his family members, started torturing me and forcefully obtained my NOC for construction permission of building. My parents gave money to the accused, Toyobraj Borguya, for construction of the building, and the accused supervised the construction work. the accused purchased all materials in his name. In the month of March 2016/2017, I went to the house of the accused as the father and mother of the accused persons went to Mumbai. During my stay, on one occasion, when I went to a marriage of my friend and returned to home, the accused along with his brothers, Talha Raj Borhuya, he is the petitioner number 2, Talha Raj, brutally assaulted me and left leg was broken due to the assault. Hearing my hue and cry, the neighboring people gathered there and rescued me and took me to the house of the cousin of the accused. On the next day, the accused took me to one village doctor, Khandal, where my broken leg got plastered. Again, I, along with the accused, Toyob Raj Borhuya, returned to rented house. The accused wanted to sort out the said plot of land and shifted to Guwahati.
Yes, I have
However, I
read.
did not agree.
So far as the PW1 is concerned, she has testified substantially. Now, what is the parameters to exercise section 319?
My lord, may I read the next para? Is important, my lord.
Yes.
141 case 127/4/2017. All the accused persons forced me to sold out the said plot of land and started torturing me.
Yes, I have read the page.
My lord, the question is that this FIR was lost on 27/12/2017.
20?
27/12/2017. And my lord, as per the evidence, my lord, herein is 41, it says on 27/4/2017. This is one of the date of occurrence. 27/4/2017. It is after 4 months of filing the FIR. After filing FIR, after 4 months, this statement. And one date is given, the cause of occurrence, my lord, that is in page 40, third para, in the month of March 2016 or 2017. Not particular date is there. This is a making story, my lord. In the month of March 2016 and 2017.
My leg was broken.
Page 40. Para 1, 4 para. In the month of March 2016 and 2017. If it is presumed that in the month of March 2016, then it is 1 year before the filing of the incident is 1 year prior to the date of filing of the FIR. And if it is presumed that it is the March of 2017,
let us accept.
Then it is also.
Let us
before
accept 2016.
After filing, then 1 year prior of filing the FIR. The delay of 1 year, my lord. In this time, my lord, the building was constructed. 3-story building is there. With my money, I constructed the building. Now, after filing this case, I have been get out from the house, my lord.
Right.
I become the victim in this case. However, my lord, section 498A may be acted against the husband, my lord. But so far, father and elder brother.
She has made so many incriminating statements against the brother-in-law and the father also.
My lord, against the brother, one incident is stated, that is the broken her leg. And it is in the month of March. It is
2016 or 2017?
27/4/2017. After the filing of FIR, my lord. After the filing of the FIR. At this evidence stage.
No, evidence of the FIR was filed when?
FIR was filed on 27/12/2017.
These are prior to that. These
9
incidents.
delay, my lord. 9 months delay. At that time, FIR was not filed.
No.
This is the dilemma.
From the point of law, you are saying, or what?
Against the brother, my lord.
There are two aspects.
Yes, my
you are challenging what?
I am telling
regarding delay.
Yes, my lord.
Or exercise of the power under section 319.
Yes, my lord.
There are
Section-
two aspects.
Yes, my lord. Section 319 may be exercised by the court, my lord, if the incriminating materials are there. But in this case, the incriminating materials is against the husband, not against the brother and father.
No, she has specifically tested. Have you,
In
have
some
you?
statement it is saying, but
Ah.
it is proved that she is telling lie, my lord.
Oh, telling lie, telling
Because
truth
the-
is not for
the
me to
opportunity-
appreciate.
Yes, my lord. Opportunity of
For
cross-examination is not given.
show me that in a 482 petition or 528 petition, we can appreciate the veracity of a statement. This is for a trial court.
My lord, yeah, therefore,
Now, we like to examine if you are challenging this order passed under section 319,
my lord.
only the parameters within which this power can be exercised. We are not testing the veracity. She is telling truth or telling lie, right? It is an evidence. It is evidence. Evidence is to be appreciated by the trial court. Tell me the legal parameters within the contours of which
Right.
the power under section 319 CrPC should be exercised.
My lord,
Have you understood my query?
my lord, my lord,
Right.
my lord,
So on the basis of this, let us assume
my lord.
that she has stated incriminating things, right, against you, both of you. Now, whether these are enough, she is yet to be cross-examined by the husband.
My lord.
You have reserved. Had she been cross-examined and thereafter demolished, it would have been different matter. Now, within these parameters, whether this court was correct in exercising 319, that is the issue. We are not examining the veracity,
Right.
truth or lie.
No, my lord, at the prima facie, my lord, she is stated the false statement. Therefore, I am.
False statement, that is
My-
what.
I refer kindly.
Please, I have said already, I have
My lord,
limited the scope of.
yes, my lord. That should be beyond, my lord, that should be proper incriminating materials against the person whom this section 319 is exercised. My lord, kindly peruse at page 45. She stated against the father that he demanded a wagoner car, my lord. Now, this is a false statement. That her statement is there, my lord. She is contradictory.
Sir,
I see, my lord, at page 45.
Sir,
the wagoner car which she
sir.
prefers is belongs to her mother's name, my lord. This
Sir,
wagoner
we
car was
are,
given to me.
I've been telling now, you are taking me to a limit now.
My lord,
Truth or
it is-
falsity?
it is clear that she stated
Mr.
against
Counsel,
my lord. My lord,
it is on record, this evidence is on record.
my lord,
Truth or falsity
my lord.
for this criminal petition is not to be preferred. Inherent jurisdiction. Right. You are challenging this 319 order.
My lord.
You ought to have challenged it by way of criminal revision petition first,
Right.
which you have not. Any view, be that as it may. Now, what is the parameters of exercising 319?
My lord, so far my understanding is concerned, my lord, the persons whom subsequently called before the court and the incriminating material.
No, that
Would
is
be-
what Mr. Counsel, that taking cognizance,
My lord.
standard is one. For framing charge, standard is slightly different. And for invoking power under section 319, the parameter is slightly higher. Now, you have to address on it.
It is true that the
Mr. Just coming to the court, iPad to ano.
My lord, may I look into Manjit Singh versus State of Haryana?
Yes, what is that?
My lord, I'm just reading
Basically, the standard is Hardeep Singh.
Hardeep Singh, and that has been discussed here, my lord.
Ah,
My lord,
Constitution means.
yes, my lord. I'm just reading those summarization, my lord. One, that while exercising the powers under section 319 and to summon the person not charge seated, here also he was not charge seated, my lord. The entire effort is not to allow the real perpetrator of a offense to get away unpunished. Two, for the empowerment of the court to ensure that the criminal administration of justice works properly. Three, the law has been properly codified and modified by the legislature under CrPC, indicating as to how the court should proceed and to ultimately find out the truth so that the innocent does not get punished, but at the same time guilty are brought to the book under the law. Four, to discharge duty, the court to find out the real truth and ensure that guilty does not go unpunished. Five, where the investigating agency, for any reason, does not array one of the real culprit as an accused, the court is not powerless in calling the said accused to face trial. Section 319 CrPC allows the court to proceed against any person who is not an accused in a case before it. The court is the sole repository of the justice, and the duty is cast upon it to uphold the rule of law, and therefore it will be inappropriate to deny the existence of such power with such court in our criminal justice system, where it is not uncommon that the real accused at times get away by the manipulating, investigating, and or the prosecuting agency. Section 319 CrPC is an enabling provision empowering the court to take appropriate steps for proceeding against any person not being an accused for also having committed the offense under trial. The power under Section 3191 can be exercised at any stage after charge sheet is filed and before the pronouncement of judgment.
That is correct.
Yes, my
These
lord.
propositions are correct.
Correct.
But question is the standard.
Standard, my lord. But in fact,
Standard.
and one case,
Because the nature of materials available before the court to invoke section 319.
yes,
Right. It is not as same as for taking cognizance of having charge.
yes,
319 is at a higher pedestal.
pedestal, my lord.
The standard to be met is higher.
My lord.
That is what I am looking at. Not these procedures are already 319. It is laid down.
Laid down, my lord.
Right.
There is
Some
one
incriminating materials are also there, but the standard
standard, my lord.
to reach satisfaction
My lord.
is a bit higher. That is what.
My lord, then
Mr. Counsel, you properly assess the code.
My lord.
It is very difficult for me to look into
My lord, I understand.
the
my lord.
standard.
My
The
lord, I
standard is that there should be fair chance of the person to be convicted. Right.
Give me some
Come
time.
up
my
with
lord, on the
better,
next-
better submissions, sir. We expect better submissions from the council. Just because throwing a petition, everything to be read by the court, this is not the,
My lord, I will.
Better
Next
to-
date, my lord. That I will.
better to have
Citation
some
not
better
there, my lord.
submissions.
Today I am not with citations.
Go through Hardeep Singh, Constitution Bench judgment. On the prayer of Mr. A.K. Azad,
My lord.
raise the case on next Thursday, did you? Next Thursday.
My lord.
Come up with better.
in fact
May-
there was, I forgot the name, my lord, where it is stated that my
The
lord,
standard is that there should be fair chance of conviction.
conviction. And my lord, there it has been discussed that in during 319, my lord, that evidence cannot be appreciated, that can be done only in trial.
That is trial.
That is trial.
But still,
No,
primacy look at the
prima
material.
facie,
And we have to see whether if there's 161 statement also,
my lord,
and she has gone ahead
develop.
and developed it
Yes.
in the trial, that is to be looked into also.
Yes,
Just because at your fancy, you cannot rope in everybody.
yes. Actually, that's why that petition was necessary.
We are not
Uh,
having the benefit of cross-examination also. Because they reject it. Okay.
May I have the date, my lord?
R.R. Kosik.
29. Fixed 20. Ablash.
Item 13.
Wait, please, Honor.
This is a criminal petition, my lord. Lordship will have a look at page 19, my lord.
Page 19.
19, my lord.
Forwarding report.
Following, because my lord, the FIR is not so, my lord. So, my lord,
Paper is not available.
available, my lord. I think my lord, the English is not up to that.
Huh?
The
We
translation.
can read the vernacular
My lord,
Assamese version.
Same, my lord.
16. Let us see 16. You are Sophor.
Suffer, my lord.
You are, okay, Sophor.
I'm
We don't really have
then
that.
reading page.
No, I always read the Assamese version.
Right.
Or the Bengali version, whatever. Not the translation one.
Yes, my lord.
প্রায় 3 বছরের আগতে ইসলাম সামাজিক বিয়া হয় বিয়ার পিছত এজাহাৰকাৰী আসামীৰ এটা সহায় কৰে এদিন কন্যা সন্তান জন্ম হয় দুমাহ যে আসামী সৈতে এজাহাৰকাৰী বিয়া হোৱাৰ পূৰ্বে দুজনী জন্ম হয় কিন্তু আজিৰ পৰা 4 বছৰ আগতে So you are stepfather?
Yes, my lord.
When the FIR was lodged? Okay.
Nine.
Yes.
Now your lordship will see, my lord. Page 19, my lord, he was arrested and forwarded to the judicial custody, my lord. That is at page 19, my lord. Now, lordship may kindly have a look, my lord, at the address, my lord. Address, my lord, village Kahikusi, PS Khetri, district Kamrup Metro, my lord. Now, my lord, page 21, my lord, he applied for bail in the court before the session judge, my lord, and he was granted bail, my lord. My lord, I'm reading the third paragraph, my lord. The learned counsel for the accused has submitted that he is innocent and not involved in the alleged offense. It is further submitted that the accused is the second husband of the informant and she married with him along with her 2 daughters from her first husband. While they were staying together, his friends hired one JCB and engaged the accused in the said work, and they gave rupees 50,000 in advance. But the informant took the entire amount, and on the next day she lost the affair with some false allegation. But subsequently, she herself sworn an affidavit that she lost the affair only due to instigation of the other person and also due to some misunderstanding, and hence she has no objection if the accused is enlarged on bail. After hearing the submission of the learned counsel, I have perused the case diary thoroughly, and it reveals that the informant also furnished a copy of the affidavit before the IO also. Further, it is seen that there is sufficient progress in the investigation of the case. The statement of most of the witnesses have already been recorded, and it is seen the victim were refused to go for medical examination. Hence, there is no medical examination report available in the case diary. So, considering the length of detention, my lord, he was released on bail, my lord. So now the investigating agency, my lord, after investigating the case, my lord, laid the charge sheet, my lord, citing, my lord, 5 numbers of witness, my lord. Now, your lordship may please turn to, my lord, page 26, my lord. This is a charge sheet, my lord. Lordship will see, my lord, name and third column, my lord, name and address of the accused person sent up for trial, my lord. Here, your lordship will see Mohammad Safar Ali, son of so-and-so, post office Kahikusi, PS Jagi Road, my lord. Earlier, it was in the FIR as well as in the forwarding report, my lord. It is the police station is Khetri, my lord. So below, your lordship will see the sign of the officer in charge, my lord, Khetri police station, Guwahati, my lord. Now, my lord, what happened, my lord? Thereafter, my lord, summons were issued, my lord, from page 29 onwards, my lord. Summons were issued, my lord. Ultimately, my lord, BWA, NBWA, NBWA. Now, lordship will turn to page 42, my lord. Page 42, my lord. Whereby NBWA.
Someone started when?
Summons started, my lord, from page 29.
NBWA started when?
My lord. From page 30, my lord. Page 30, my lord. 8/12/21.
Summons.
Summons.
BWA. Then NBWA started.
It starts at page 42, my lord. This is the order, my lord. 7/1/23. Accused
7/1/23,
my lord. The type copy is it at
27/1.
27. Type copy is 41, my lord. BWA issued not yet returned. Notice to the bailer return answered with report. Issue fresh NBWA to the accused and notice to the bailer fixing so and so, my lord. Now, my lord, lordship will turn to page 46, my lord. 46, my lord. This is the order dated 17/06/23, my lord. Accused is absent. PNA issued not yet returned. Call for a report from the OC of the concerned PS as to why the report has not been returned to the issuing court. Now, next page, my lord, 47, my lord. This is important, my lord. Accused is absent. PNA report call for from OC Jagi Road, my lord. Although the case is from Khetri, my lord, they are sending the summons to, my lord, the Jagi Road PS.
You are saying that you are Khetri.
Khetri, my lord. So a report was called from the OC Jagi Road. Hence, OC Jagi Road PS is directed to appear personally also. (48) also same, my lord. Page 48, my lord. Now the last page, my lord, page 54, my lord.
Yes, Mr. Goswami. Now he is saying that Khetri, not Jagi Road.
So I had made a specific statement, my lord. Page 7, my lord, paragraph 8, my lord. Ultimately, they came, my lord. May I read, my lord? Page 7, paragraph 8.
Yes.
That has to be verified, madam. That has to be verified, madam.
What?
I will appear, my lord.
Will appear. We'll keep
only
it
thing
in
is that, my
abeyance.
lord,
It
this
is
is-
unlike the other case.
Unlike the other case.
And one more submission, my lord, that informant and me, my lord, living together right now in the same residence.
The only thing is that my POXO case, madam, whether notice is required.
Appearance notice will be required or not?
No, because
But notice is not required. For what?
as per Deepak Naik judgment, madam, I'm not sure.
We are keeping the thing in abeyance. The matter of granting bail is in the discretion of the trial court. Only thing is that he should not be taken into custody in execution of the warrant of arrest. Let him explain before the trial court whether he is to be granted bail or not. That is the discretion of the trial court. We cannot quash the NBWA. It has been rightly or wrongly, whatever it is. Heard, Mr. NJ. Dr. Learned Counsel for the petitioner. And Mr. R. Kosik Learned, Additional Public Prosecutor for the respondent states. The instant criminal petition under section 528 Bharatiya Nagorik Suraksha Honika 2023 BNSS is preferred to assail an order dated 23/2/2022 and subsequent orders passed by the Court of Learned Additional Session Judge Special Judge Pokso, Kamrup Metro, Guwahati, within bracket Special Court during the proceedings of sessions. In the course of the proceedings of sessions.
Item number 14.
Yeah, please, Your Lordship. This matter was listed last week, Lordship. This is for expedition of the trial, Lordship.
Huh?
Expedition of the trial. The matter was, Lordship, we have filed a criminal complaint. The matter was listed, Lordship. The impugn order is at page 32.
Page 32?
Last page, Lordship, of the petition.
Yes.
It was first listed on 21/7, just last month, Lordship. And the next date is given 10/12/25. That is after 6 months without any reason, Lordship. 6 months gap, Lordship. Between
Anything, any procedure?
Lordship,
You come
I have
across
studied,
anything?
I have studied some, gathered some case, but specifically, Lordship, there is a judgment of the Honorable Supreme Court. Although that judgment, High Court has allowed it previously, then it was set aside on the ground of locus standi of the complainant, but there was an observation of the Honorable Supreme Court, Lordship, that under 482 High Courts have wide powers.
So wide powers is there, but
Wide
fixing a
powers to
date is
expedite the
different.
trial, Lordship. Wide powers to expedite the trial, Lordship.
Yes, criminal practice manual.
But
Anything you have come across?
my lord, actually this matter was looked into by Mr. Goswami, my lord. But
Okay.
that day I also gone through that criminal practice rule,
Okay.
not found anything. my lord.
Practice and manual?
Yes, my lord.
So, Lordship, the date between the first date and the next second date is too long, Lordship.
That I understand, but where is the question of interference? We
Lordship,
try to find out where it means. That is why we have asked you for your.
Para 11 of the judgment which I have perused. Lordship, I have underlined. May I read, Lordship? I have marked, Lordship, para 11. It is also well settled that high courts in appropriate cases can very well under section 482 CrPC or in any other proceeding can always direct trial court to expedite the criminal trial and issue such order as may be necessary. Lordship, in this case, basically, we want the interference of this honorable court on this ground only, Lordship, because it is only 6 months date between the first date and
That I understand. I am trying to be on your side. But question is where to, because otherwise you cannot fix a date. That is also the law. That the courts have independent power. But business of the court, how it is to be fixed, it is for that court is to decide, right?
Correct, Lord.
But is there anything somewhere in a criminal manual practice? That is what I need assistance on that aspect.
That I have checked that day itself here, my lord. I have not found anything regarding
But
that.
some guidelines somewhere.
But that I have to look into again.
In Bombay, it is invariably 6 months. No question. Supreme Court also did not interfere. 6 months, every date. In Bombay. No interference. Okay, let me examine. We'll put it on another date. We'll find out.
Lordship.
See guidelines. Some guidelines somewhere laid down. Otherwise, I also feel that it is the period is bit long. Okay, J. Pegu, learned.
Ekakoti, Lordship.
Ekakoti, learned counsel for the petitioner, and Mr. R. Kosik, learned additional public prosecutor for the state, responsible state are present. So stop. The learned counsel for the parties have sought accommodation to address on the issue involved. Place the case on Wednesday. Find out.
Lordship, Wednesday I will not be there, Lordship. Next Friday, Lordship.
Next Friday.
29.
It is not this Friday.
Next 29.
2908. Item 15.
May I please, Your Lordship?
Yes.
It is an application for setting aside the impugned 7 orders passed by the learned Chief Judicial Magistrate Dibrugarh issuing warrant of arrest against the petitioner in NI case number 158 of 15. Lordship, on
Which one? Page?
page 3, Lordship.
Why?
Actually, this is conviction case, NI conviction case. On 27/9/2019, the judgment was passed against the petitioner, whereby he was sentenced to
Where is
convict
the trial court order,
trial court order.
judgment?
Judgment
3 lakh.
is page number 14. Lordship.
3 lakh.
Yes, Lordship, 3 lakhs.
Then appellate court.
Then appellate court dismissed the appeal, and thereby he preferred an criminal revision petition
Revision petition where?
before this honorable court.
What is the?
After along with a IA for to condone the delay of 106 days, Lordship. The order is in page number 106, Lordship. The order of IA dated 5/11/24.
106.
Yes, 106. And after dismissal of the
106.
yes. Thereafter, it was not listed.
Issue notice. You make it listed.
Yes, Lordship.
That order cannot be
Yes.
passed here.
Yes, have to be.
Suspension of sentence
Yes.
will automatically
Yes.
result in recall of the NBWA.
Yes.
And for that, you have to offer
Yes. Yes.
something
Yes.
under section 148.
Yes.
This petition is misconceived.
But Lordship, after the petition
When
was
a
filed,
proceeding is pending,
yes,
where that order can be passed regarding suspension of sentence,
yes.
another petition is misconceived.
But Lordship,
That cannot be a ground. You have to expedite that by making mention, getting it listed.
no, Lordship, my ground is after LCR received by the trial court.
That is not a law, perhaps. I don't. I have not.
I was represented by my learned English counsel on 20.
There is concurrent finding of facts and concurrent conviction and sentence.
Yes.
Right. The natural consequence is that unless you get an order of suspension or execution of sentence, the accused convict is to be
Yes.
taken into custody.
Yes.
That is a normal consequence, and exactly it has been written. Page
But
1.
But he have preferred an criminal revision petition,
Madam,
which is pending.
Madam, you have to get the order in that criminal revision petition and the IA,
But for that,
not here.
I have to be disposed of.
When
Yes.
I cannot order a parallel proceeding, I cannot pass any order in the parallel proceeding.
Yes.
You get it listed that IA,
But I was not aware about that I.
not required. When you were a convict,
Yes. But once on 29/10/24, I was represented by my learned counsel, and it was informed by him that there is that I have preferred.
how long can, you are in revision, right?
Yes.
At this stage, you are not protected by also 389 CrPC. In revision, the issue is different. It is misconceived, this petition. You get it, the criminal revision petition listed earlier along with the IA. Get a proper order.
But now I am apprehending my arrest.
This is misconceived, madam. You should have made prayer for early listing of the IA. And should have given an undertaking that yes, I am depositing 20%. Or if you can make out an exceptional case for exemption, make out an exemption case there, the court would pass an order on the first day itself.
Yes, Lordship.
If you offer 20% on the first day itself, would have been suspended. Bro, this is misconcept. We have to close. Yes, Mr. Kosik, any way out?
Seems
I
the
cannot pass any
premature, my
parallel order in a parallel proceeding.
my lord. In fact, the court below, learned court below orders, your lordship go. should-
Perfectly
Yes, my lord, and my
in
lord,
tune.
and in fact, my
But
lord,
miss-
initially on 30/12/24, fixing 29/1/25 for appearance, order of the Honorable Guwahati High Court. That seems, my lord, the court has been informed that they have prepared an
Yes,
Because
that
that-
must be presented.
That hands of that court is also tied.
tight, my lord.
But I was not informed,
What?
otherwise, I could.
You are an
order-
convict now,
Yes,
and your presumption of innocence is gone in the trial court, and that has been affirmed by the appellate court.
but kindly peruse the page number 107, Lordship. 108, Lordship.
107, I have seen.
108, Lordship.
108 also I have seen.
Yes. Furnish appropriate order of the Honorable Guwahati High Court. But it was not informed by my learned counsel. As on 5/11/24, the IA order was passed. I could have furnished the order on 30/12/24.
Madam, I have heard you enough, but could not help you. Trial court is perfectly right in passing the order.
But my
That hurts.
non-appearance is not delivered.
Non-appearance, the question of non-appearance does not arise. You are convict.
But because of non-appearance, the warrant of arrest has been issued.
Madam, how long you have put in your practice?
5 years, Lordship.
Heard. Miss Edas,
It does.
learned counsel for the petitioner. And Mr. R.R. Kosik, learned additional public prosecutor. For the respondent number 1, State of Assam, full stop. Having regard to the issue involved, raised in this petition, the petition is taken up for consideration of the motion stage itself, dispensing with the notice, procedure of issuance of notice to the respondent number 2, full stop. The instant criminal petition and the 528 BNSS is preferred, assailing a number of orders passed during the period from 30/12/2024 to 5/8/2025 by the Court of Learned Chief Judicial Magistrate, Dibrugarh at Dibrugarh, within bracket trial court, whereby the trial court has issued warrants of arrest against the petitioner in connection with a complaint case, NI case number 158 of 2025, full stop. It is pertinent to state that the respondent number 2 as the complainant, it is relevant to state that the respondent number 2 as the complainant instituted a proceeding before the Court of Learned Chief Judicial Magistrate in the year 2015 by filing a complaint with the allegation that against the petitioner herein as the accused, alleging commission of an offense under section 138 of the Negotiable Instrument Act. Full stop. The said complaint case was registered as CR case number 158 of 2025. Full stop. After conclusion of the proceedings, the trial court passed a judgment dated 27/9/2019, holding the accused comma, that is the petitioner herein guilty of the offense under section 138 of NI Act and sentenced him to pay a fine of rupees 3 lakh as compensation to the complainant in default, comma, to undergo simple imprisonment for 6 months. Full stop. The accused in CR case number 158/2025, that is the petitioner herein, took the matter into appeal before the court of Land Station Judge Dibrugarh by criminal appeal number 35 within bracket 4/2019. Full stop. The said criminal appeal, the appellate court, after hearing the parties and after appreciation of the materials on record, comma, found no merit in the appeal and by right a judgment dated 21/3/2024, while dismissing the appeal, comma, has affirmed the judgment in order dated 27/9/2019 passed by of conviction and sentence passed by the relevant trial court. Full stop. Para. It is stated in the instant petition that the petitioner, being agreed by and dissatisfied with the concurrent findings of the trial court and the appellate court, has already preferred a criminal revision petition, comma, criminal revision petition number 9645/2024 before this court, along with an interlocutory application, comma, IA criminal number 1027/2024. Full stop. It has emerged from the materials on record that in IA criminal 1027/2024, comma, this court or comma on 5/11/2024, comma, issued notices to the opposite parties. Full stop. The prayer made in IA so and so is for suspension of the execution of the sentence passed against the petitioner by the trial court, comma, affirmed by the appellate court. Full stop. But in the meantime, comma, the trial court took up the matter of CR case number 15/2015. Full stop. When the process issued for securing the appearance of the convict, that is the petitioner, did not result in appearance of the petitioner, comma, the trial court by the orders, comma, mentioned above, comma, issued order for issuance of warrant of arrest against the convict. Full stop. On 6/6/2025, comma, the trial court has passed the following order. Page 112. Para. As an application for suspension of the execution of the sentence passed against the petitioner as the convict by the trial court and affirmed by the appellate court is pending in the form of I criminal in a parallel proceedings before this court in the form of criminal revision petition number so and so and I criminal number so and so, comma, the the petitioner prayer for suspension of the execution of the sentence can only be considered in such parallel proceedings. Full stop. The orders passed by the learned trial court in view of non-presentation of any order from this court regarding suspension of execution of a sentence passed against the convict, the trial court the orders passed by the learned trial court are found to be in conformity with the conformity for is found to be conformity with the conformity in law. Full stop. As the petitioners prayer for recalling of warrant can only be considered in the parallel proceedings in so and so and so and so, this criminal petition preferred under section 528 is found to be misconceived, and therefore, the same is dismissed.
Item 16.
May please, your lordship. My lord, this is also a case relating to NI Act, my lord. NI Act. In fact, my lord, the present criminal petition, my lord, is directed against an order dated 2/8/25, passed by the additional session judge Barbeta.
At what stage?
Lord, in fact, the prayer for dispensing with the deposit of, my lord, interim compensation was, my lord, rejected. Against such a rejection, my lord, the present petition has been, my lord, filed. In fact, my lord, the submission was made before the learned appellate court, saying that 139 of the NI Act, my lord, normally does
You mean
not
to say which provision?
My lord, in fact, the
Which provision? 148 or 143A?
148 requires
No, after conviction.
after conviction.
After conviction.
After conviction, man.
During the appellate stage.
Yes, appeal was filed.
So this additional session judge, he is exercising appellate power.
Appellate power under 148, man.
Where is the trial court judgment?
Trial court judgment, your lordship will find at page, my lord, 52. It starts from 52, annexer 8. Now, my lord, what I was trying to draw your lordship's attention was, before that, my lord, sentence, my lord, is of fine of rupees 5,48,000 or 40,000, my lord. And in default, my lord, simple imprisonment of 3 months without, my lord, any sentence of imprisonment. Now, my lord, before the learned appellate court, my lord, the submission was sought to be made that the complainant, my lord, in fact, failed to prove, my lord, some foundational facts. Because the case of the complainant was that 5,40,000 was handed over to the accused. So they are only acquainted with, neither a family member nor a friend, nothing. Now, this handing over of the amount is without any documentary evidence. No money receipt, no agreement, nothing, absolutely nothing. And it is also not the case of the, my lord, complainant that some witness, my lord, was present while handing it over. And secondly, my lord, it comes from the trial court observation also. The accused claims himself to be a businessman, but no document regarding, my lord, balance sheet. He says, my lord, he has certain company or like that. No balance sheet, income and expenditure, IT return, absolutely nothing. So these facts, my lord, in fact, in the cross-examination, these, my lord, questions were put. Now,
your position as on date is a convict.
Correct, my lord. Correct.
Presumption of innocence is not available.
Not available, but my lord, what I'm trying to say.
That is gone unless it is.
Lordship is correct, my lord. What I'm trying to say, 139 is there under NIA, but normally it will not automatically come into play.
That is presumption.
Presumption.
139.
Yes.
Rebuttable.
Rebuttable presumption.
But here is a judgment.
Well,
now, staring at your face.
Correct.
That holding you a convict.
My lord. That is correct.
143A is a different issue.
Yes.
148 is another issue.
My lord.
Now, to come out or to extricate yourself out.
Yes.
Now, what I have shown much now, that unless it is an exceptional case.
Correct.
That is now, then otherwise, 20% is
My lord,
to be done.
Yes.
Because much water has flown after
My lord.
incorporation of that
Correct.
section 148. Now, interpretation has been made by various judgments.
Yes.
Right, recently.
My lord.
So 148, yes, can be.
My lord.
But question is whether it is an exceptional case or not. If it is not an exceptional case, then 20% is to be there.
Correct.
No discussion.
My lord, this, recently I have come across a recent judgment. My lord, the expression which
Mr.
finds.
Talwar, because I'll be running short of
My
time
lord,
today.
can it be
So,
some other day?
Some other day.
Yes.
We'll
Because my lord,
hear you in detail.
only for my lord, my satisfaction, the expression may, which finds place in 148, earlier that was, my lord, constituted to be shall.
Yes.
Now, my lord, may has been, my lord,
We'll read the judgments together.
Yes, yes, correct, correct. I'll try to satisfy.
Yes, definitely.
And my lord, this is a fourth grade employee. Now, my lord, 5,40,000 will amount to 1,08,000. The sweeper, my lord.
So we are concerned with only 20%.
Correct. 20%, 1,08,000. That will constitute. That, my lord, she will face some difficulty, my lord.
Ask it, Talwar. Counsel for the petition is present. Lays the case on next week.
Next week.
Tuesday or Wednesday.
My lord. Wednesday, can it be on Tuesday? Wednesday, I have some personal inconvenience, my lord.
Tuesday, so many cases.
Then, my lord.
Thursday. 28.
28, Thursday?
Thursday, no? Just, Lord, should kindly give me some time. 20. Yes, Thursday, 28, correct. No? Obliged.
Item number 18.
Please, my lord. Am I
Yes.
audible? Well, this is a matter. Petitioners before my lords are directors of a company, Brahmaputra Iron Steel Company Private Limited. Before taking my lords to the impugned order, just a little background. The petitioners are directors of a company, Brahmaputra Iron and Steel Company Private Limited. This company was bought by the petitioners in a liquidation process, which has been approved by the NCLT Guwahati. What had happened here is the company was under certain debts and default. The company went into a voluntary insolvency under Section 10 of the IBC. That was allowed by NCLT, and a resolution professional was appointed, and the moratorium kicked in, etc. All of that happened. The resolution professional and the COC did not get any bids for reviving the company. Nobody showed interest. So the committee of creditors and the resolution professional then decided to go for liquidation, and it was sent for liquidation. And then the resolution professional / liquidator made an application to sell this company as a going concern. To sell the company as a going concern at whatever rate they get. So a rate was fixed, a benchmark was fixed, and an auction was held. Reserve price was fixed, and an auction was held. I am an auction purchaser who purchased this company. And after purchasing this company, that auction purchase was confirmed by NCLT. I have annexed all those orders. Was confirmed by NCLT. And after it was confirmed, NCLT, keeping in mind the Edelweiss judgment, has also granted me certain relaxations and benefits. Because I come in and we start the company on a clean slate. So I should not be responsible for the prosecutions which took place prior to the insolvency. Or I should not be liable for any monies due prior to the insolvency. So since I have come in to start the company again, to revive the company on a clean slate, there are certain liabilities that I get immunity from. Now all of this happened. I get the immunity, the NCLT confirms that I get the benefit of Section 32A of the IBC, because Section 32A specifically provides that any prosecution which is pending at the time of commencement of CIRP, that will not affect or that will not continue against the new people who come in, the new management that comes in. So NCLT Guwahati grants me that protection or that benefit under 32A. Now all of this happens. After that, I become a director in August 2024. And after that, now in July 2025, the impugned order is passed, which impugned order my lords will find at page 59. What appears is that there was a CBI proceeding which was pending against the directors of this company, the erstwhile directors. May I read page 59?
Okay.
CBI is duly represented, accused person Santosh Jaiswal and Padmanath Deka absent with steps with a petition number so and so showing cause which is seen, heard and allowed considering the ground shown. Today was fixed for report from the CBI. This
Yes.
report is...
So in place of this erstwhile directors, you have been roped in.
I have been roped in and I have been summoned. And the
Yes.
summoned my lord...
Shall I start or?
No, just what is your
There is a
initial view?
initial view is that they have received one summon to accused person. This is again, this has been issued in the case number, that is CBI case issued by the magistrate to MS Rekha Surana, and another one is Sarika Surana. The thing is that the Brahmaputra Steel and Company went on insolvency under section 10. When no resolution plan has come, it has went to the liquidation. So it has been sold as it is condition.
As a going
It is as a going concern. Now, they are director, they are exonerated, but there is a Supreme Court judgment is there. Somebody has to represent the company. So for the
Somebody is to represent the company is all right, because it is a de jure complaint.
Yes,
De jure,
yes,
right?
Your Lordship.
It is a juristic entity. It must be represented by somebody.
Yes, Your Lordship.
But here, the peculiar facts of the
In a
case,
to that effect,
whether somebody had committed, the erstwhile director had committed 420.
so against them, no.
So they will incur the liability.
No, Lordship, I am coming to, because in the NCLT, what happened, when they give a resolution plan, there are certain exemption and concession. Here, there is no resolution plan. They have filed an application under 60 of the IBC.
IBC, I am not very much aware of.
Because I was judicial member of the NCLT.
Okay, good enough.
So in that what happened, I am apprising Your Lordship.
Okay.
They prayed for certain concession and relaxation. To that effect, there is an order, Your Lordship. I am bringing to the page number, their application. That concession
What
has...
provision you said, Mr. Talukdar?
But
That concession has not been given.
32A.
I have never read IBC till now.
But ma'am, before that, may I show page 57?
I have to book, Your Lordship.
I have to candidly admit.
So, but before that, my lord, may I show page?
Oh, it's such a big act.
Lordship, page number 56.
1 minute. Section?
32A.
Yes, there is judgment also on 32. There is a judgment also on 32.
May I read? May I
Very
read?
difficult.
May I read? 32A1.
Mr. Talukdar and Ms. Devi,
It's
court they needs to understand the meaning of many terms.
Yes, my lord, I can assist, my lord. May I just read? May I read 32A1 for a moment? Notwithstanding anything to the contrary contained in the code or any law for a time being enforced, the liability of a corporate debtor, that is the company which goes under insolvency, that is the corporate debtor, company under insolvency, for an offence committed prior to the commencement of the corporate insolvency resolution process, that is prior to the petition under CIRP being admitted. So before a petition is filed to take a company to insolvency, before a petition is filed, if certain offence took place or if certain liabilities arose, those liabilities are liabilities prior to the CIRP, because the CIRP corporate insolvency resolution process starts as soon as a petition against the corporate debtor is admitted by the NCLT. prior to the commencement of the corporate insolvency resolution process shall cease, and the corporate debtor shall not be prosecuted for any offence from the date of the resolution plan. In this case, resolution plan did not happen. In this case, a liquidation happened. Resolution plan has been approved by the adjudicating authority under section 31. If the resolution plan results in change in management or control of the corporate debtor to a person who was not, we don't fall under AB. Well, may I just once for a moment just give the scheme of IBC? Just the overview of the scheme. On my let me fix it another day. I'll make a note because anyway the summons is on 19th of September. I am not pressing for a stay to the notice may be issued.
No, we understand. We'll understand.
May I please your
No
lordship?
problem, no issue.
In 32A3. it
So
says-
what are the provisions, what are the provisions required to be read?
Here the company went into insolvency under section 10. It was a voluntary insolvency.
Up to what provision? Up to 32A?
32A?
Or liquidation process is also there, chapter 3.
The fact that a liquidation happened.
Mr. Talwar, to understand.
Oh, no, it will
What are the provisions, up to what provisions the court has to read to understand the meaning of the process?
So in addition to this, there are also regulations, which is the insolvency regulation.
Okay.
May I just show for a moment page 37? Page 37 of the petition. For some clarity, my lord. And if my lord takes page 39, para 1. This is the order which gave me certain relaxations. This is after the insolvency liquidation happened, para 1. This interlocutory application has been filed under Rule 11 of NCLT rules, read with 65 of the Insolvency and Bankruptcy Court by Sarita Bothra as the petitioner.
Mr. Talwar, we'll put it tomorrow. I'll read the file.
My lord, then in that case, Monday, my lord.
Monday is holiday.
Then Tuesday, Wednesday, next week, my lord.
Okay. Tuesday, did you?
Tuesday means which date? 26th.
Okay, K. Talwar. Petitioner. Petitioners.
If I be permitted, I will
MDB.
explain the thing.
Understanding also CBI. Present. When? Tuesday?
Tuesday, 27th.
That's
no
okay.
problem.
This is the case on Tuesday. I'll get ready.
But
But
here,
I'll prepare a note for my lord. I'll prepare a note for my lord.
it is a very simple thing.
Simple terms.
The terms, if I
Let
be
me
permitted,
grasp it. Let
if
me
I-
grasp.
Then I be permitted, I will make
You
it.
give the opportunity to grasp it.
Your Honor.
Supplementary list.
I'm good.
Item
By the time I could be also better than you.
Yes, well, I'm certain about that, my lord. I'm certain about
Possibility is there.
I'm certain about that. I'm good.
Next.
Item 45.
Yes, sir. Life imprisonment.
Life imprisonment, Lordship.
Uh-huh.
So may I place one judgment, Lordship?
Please.
Package file. Lordship may peruse the paragraph 106.
Paragraph?
106. 102, Lordship, page 117. Lordship. 102, page 117, Lordship. Paragraph 102, Lordship.
102. You want to show Rajiv Chaudhary? No, that is not the issue here.
Lordship, when there is a
Rajiv Chaudhary is not the issue. Section what? Section 395.
Lordship, 395.
There are two parts to it.
Two parts, Lordship.
One ends
Life.
at
Lordship.
life imprisonment, comma.
Lordship.
The other part starts then 10 years or something like that.
Lordship.
So in which cases the life imprisonment is to be awarded? That interpretation, not Rajiv Chaudhary. Rajiv Chaudhary is for 60 days, 90 days.
90 days, Lordship. Where two punishments is there, Lordship, higher.
60 days, 90 days.
Lordship.
Rakesh Paul. I want an assistance from you, sir. to give you relief within the limited space with some observation. Read big books on IPC. Ratanlal Dhirajlal. Friday. According to repeat for you. Yes, have you come out?
I have also not.
Okay.
Because there are text to text.
I don't find time myself to look into it.
In fact,
Next.
For admission, item number 19.
May I please, Your Lordship?
Yes.
Paying for causing of charge as well as entire criminal proceeding, Lordship. That
Either here it's to some extent.
Lordship.
Huh?
Earlier on 13 minutes.
Yes, anything?
Because they are that.
That day, Mr.
So I was there.
Nur Mohammed was not there.
No, my father was there. He was expired, Lordship.
Oh. Yes, you were not there.
Yes, Lordship. Yes, Lordship.
Yes, what about it?
Lordship, the petitioner came for the Lordship first proceeding, first trial, first case. Lordship. There are two FIRs, Lordship. In this case, Lordship. They have came for the Lordship, the first FIR, Lordship. The trial is going on, Lordship.
Paper page 21. Same cause of action, same informant, Lordship, same amount,
Lordship, but Lordship, they have got stayed in the second FIR, Lordship.
Second FIR is the subject matter of this case?
Yes,
Same, Lordship.
same,
But it is,
same informant, same.
but that is stayed, Lordship. Lordship, this FIR may go on merit, Lordship.
Definitely tomorrow. Tomorrow we'll go. We are going. We'll close this way or that way.
Lordship.
Place the case tomorrow. Naam likh do.
Item number 20.
To be heading niki? Jail bill. There's appeal from jail. Is directed against a judgment and order dated 22/7/2024 passed by the Court of Learned Additional Session Judge Hiba Harbor. Trial court. In sessions case number 83 within bracket SN of 2023 by the judgment and order dated so and so. The accused appellant has been convicted for the offences under section 307 IPC and section 326 IPC, full stop. For the offence under section 307 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of ₹5,000 in with default stipulation. No separate sentence has been passed under section 326, IPC. The criminal appeal is admitted for hearing. The case records of so-and-so be called for issue notice returnable in 4 weeks. As Mr. Kosik, additional public prosecutor has entered appearance on behalf of the respondent state of Assam. The issuance of formal notice to the state respondent is dispensed with. To represent the case on behalf of the accused appellant, the court deems it fit to appoint Sri singular body no? Sri Oruna Pugon from the panel of amicus curiae. Post of the amicus curiae, Ms. Sri Oruna Pugon is to be notified accordingly. This is the case after 4 weeks. The criminal appeal under section 415. ভারতীয় নাগরিক সুরক্ষা সংহিতা is preferred against the judgment and order dated 11/2/2025, passed by the Court of London, Special Judge POXO at Golaghat Special Court. In Special POXO case number 82 of 2019, which arose out of Bogijan Police Station, case number 61/2019, by the judgment and order dated so and so, the accused appellant has been convicted for the offences under section 4, POXO Act and section 506 IPC. Sorry. Section 376 1 IPC and section 448 IPC. Post for the offense under section 376 IPC, the accused appellant has been sentenced to undergo rigorous imprisonment for 10 years and to pay fine of rupees 10,000 with default stipulation. Post for the offense under section 448, he has been sentenced to undergo simple imprisonment for 1 year. The criminal appeal is admitted for hearing. I have gone through the grounds urged in the memorandum of appeal. Criminal appeal is admitted for hearing. The case records of so-and-so declared for issue notice returnable in so-and-so. The accused appellant, as Mr. Kosik has appeared accepted for the respondent number 1. The accused appellant to take steps for service of notice upon the respondent number 2 by registered posted AD as well as by usual process within 3 working days from today. The name of Mr. B. Haldar, Learned Legal Aid Counsel appointed for the criminal appeal is to be reflected in the cause list. This is the case after 4 weeks.
Item 22.
Item 22 should be listed before DB one.
I know, yes. And what about the two appellants? What will happen to the other one? Come to page 10.
10.
Two appellants.
Yes.
Two convicts.
Two convicts.
Two appellants. Different sentences.
One is 5 years.
Huh? Is there any provision, separate provision?
That I have to look into that.
No, 370. 430 only. BNS.
Well, in fact, that's while your lawsuit was in DV, similar issue was cropped up. Similar issue was cropped up.
Was it answered?
That was not answered that time.
530 or 550. Sorry, 415, no? 415. It is not clear, say High Court, it is only say High Court. A single bench, double bench, division bench, notification from Asani. Heard Mr. J. Das, Learned Legal Aid Counsel for the accused appellants, and Mr. R. Kosik, Learned Additional Public Prosecutor for the respondent state. Full stop. Two appellants have preferred the instant criminal appeal under section 415. Within bracket 2 on the Bharatiya Nagari Khodaka Honita 2023. To assail a judgment in order dated 18/6/2025, passed by the Court of London, Additional Session Judge Special Judge POXO Moriga. In POXO case number 132 of 2020, which arose out of Nikit Bhatta Police Station case number 119 of 2024. Post up by the judgment and order dated 18/6/2025, the accused appellant number 1 has been convicted for the offense under
It's not, I think, Chinese.
POCSO Act, and Section 87, Bharatiya Nyaya Sanhita, and full stop. For the offense under Section 6 POCSO Act, accused appellant number 1 has been sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 30,000 with default stipulation. For the offense under Section 87 BNS, he has been sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 10,000 with default stipulation. Page 45 of us, yeah? On the other hand, the accused appellant number 2 has been convicted for the offense under Section 96. BNS, and she has been sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 10,000 with default stipulation. Post up. As the accused appellant number 1 has been sentenced to undergo rigorous imprisonment of 20 years, to the appeal in respect of the respondent number accused appellant number 1 is to be heard by division bench as per the notification number notification dated 17/9/2019. Post up. The registry to examine the matter and thereafter this started before appropriate dates.
Item number 23. Process a criminal appeal against conviction. The impugnment order at page 19 and the operative part of page 34. The last occasion the legal counsel was not present.
Judgment has been convicted to the offense is 448, 366, 3 years. Offense under section 3 years. Yes. Hey, in here, এই কালিয়াটা দিছিল সাসপেনশন আৰু পক্সয় আৰু এটা আজি দিছিল না এটা আৰু এটা কালি আমাৰ হেৰি দিছিল না বসুমতী ইয়েস then what happened?
Now, what I intend to point out before your lordships is that, my lord, this cognizance has been taken under 341, 506 and 186. And if your lordship sees into these provisions, your lordship will find whoever. That means it is that particular person, my lord, who, my lord, commits, my lord, these offences, my lord. 341 is wrongful restraint, my lord. 506 is, my lord, criminal intimidation, my lord. And 186 is whoever obstructs a public servant, my lord, that your lordships have just seen, my lord. So in none of this, my lord, these evidences which has now been brought on record by way of that trial court records, my lord, this person who is before your lordships, my lord, who has been charge-sheeted, my lord, he is
how many
nowhere.
charge-sheeted?
My lord, only one.
Only one.
Only one, my lord. And my lord, kindly sees, my lord, the note of the police, my lord. They say, my lord, that they had picked up so many people, but they could not identify those people, my lord, persons. And my lord, who has been charge-sheeted, my lord,
Yes,
this man,
sir.
my name, my lord, President of my lord Congress.
Charge-sheet, so materials are there.
Materials, yes, has to be there.
Material are there. You have to examine.
Examine it.
Have you examined?
No, I today have not examined.
You should have examined.
I'll examine.
Because if these ingredients of these offences are not there, no question to proceed with the trial.
I'll examine.
Because wrongful restraint has to be attributed to that person.
My lord.
There has to be specific
My lord.
instance.
Yes, my lord.
And that public servant also 186 to attract and 506, there has to be evidence.
Yes.
Criminal
There
intimidation.
is the evidence of 3 persons under 161, my lord. Kindly see what they have stated. Nobody has implicated this particular man because this man was in Silchar. He was not in Karimganj at any point of time.
Look at it, look at
No,
it. These are the only thing. How many were examined?
3, my lord.
Only 3.
Yes, my lord. One
So
bank
very,
manager,
very, very
one-
less.
one school teacher and one somebody, my lord.
Okay. Are you annexed? Have
No,
you
it is
annexed?
there, my lord. In that trial court record which has come, my lord, the scan copy, it is there, my lord.
Oh. Bangla.
Bangla. As your lordships commented in the day, my lord, your lordships reads, my lord, Bangla. So that is why it is presented in that language, my lord.
Yes, Mr. Go to it.
Yes, I'll go through my.
You can take up tomorrow since
Yes,
we have
yes. They'll go through.
provided time permits.
My lord. Yes. My lord, if your lordships permits, my lord, can I also have a copy of that, my lord, so that I can also.
You can
accept
have,
your
you can
lordship-
have, you can read. LCR is, you are entitled otherwise under section 207.
Yes, ma'am.
Yes, I know what is that.
You can have a look. We can have it tomorrow.
Yes.
Z Chaudhary petition. And Mr. MP Usam learned additional public prosecutor for the respondent states are present as the scanned copies are received of the TCR is received. The learned counsel for the parties want to have a want to produce the same and as short for list the case tomorrow. Three statements.
Yes.
Item 27.
May I press lordship?
Yes,
Lordship,
madam.
lordship, last time your lordship was supposed to get the instruction from the PP lordship as to whether
Something,
against me or.
yes. Search it. I don't know for what reason it was required.
This person, my lord, he has claimed for Jimma, my lord, but now my Jimma has been rejected, my lord, and he is the owner of the vehicle. The lordship will. Yes.
Accused person.
Yes, my lord.
Yes, he has been succeeded or not?
Yes, he is not succeeded, my lord. As just now I have my lordship permit me to read from my mobile, my lord. Just now I got a.
You have received?
Just now, yes.
Search it or
Yes.
information?
Yes, my search sheet laid down, but he is not sent for trial, my lord.
And offense is under what?
Offense under lordship, that is.
Diesel.
Yes.
Much lesser than NDPS.
7, yes. Again,
So
section 7 of.
even we apply Biswajit Day,
Biswajit Day, my lord.
right?
Yes.
I think he'll get it. কোন কেইটা কালি ফিক্স কৰিছিলো এইকেইটা প্ৰথম লৈ লওঁ এইটো কৰি দিওঁ এইটো কৰি দিওঁ You have received my instruction?
Yes, madam.
We can put it on disposal for disposal
Yes.
tomorrow.
Yes.
All the 5 will be taken up one after other.
Yes, yes.
Okay. Paying will be there?
Lordship.
Okay, miss.
Airpine. Airpine.
You are applying. Okay. Learning counsel for the petition. And Mr. MP Goswami, in addition, public prosecutor for the respondent state. At present, Mr. Goswami has submitted that he has received instruction as regards submission of the search sheet and the person's search sheet.
Yes.
Full stop. As sought for by the land council for the parties, list the case tomorrow. We'll take up
Yes.
these cases which have been fixed
Yes.
earlier. Kal ki asli list one?
Obliged, Lordship.
Because I'm not sure about my Friday.
Lord.
We'll go one by one. If time permits, whatever can be disposed of.
Number 29.
Is a matter about, yes, what is the matter about?
Your Lordship, CBI has submitted a reply. So we have received it on today only. So
Okay.
kindly grant us some time,
How much time?
at least 2 weeks.
Okay, Mr.
BU Laskar.
B.U. Laskar. Council for the petition, Miss
And Chaudhary.
Ann Chaudhary, and council appearing for the respondent CBI. I have, no, sorry, for the respondent CBI representative, Mr. Laskar has submitted that he has received a copy of the reply
Reply.
of the CBI today.
Correct.
And he needs to go through the same. He needs some time to go through the same and to file a response if so advised. Full stop. As sought for by Mr. Laskar and counsel for the petition, lays the case after 2 weeks.
A date may be fixed, your Lordship. 6th of September.
This is the case on.
Saturday.
so- After that, no, not up to 10th, not up to 10th September. We have been fixing many cases. Thereafter. 15.
Obliged.
Supplementary list, item 46.
Please, your Lordship. My Lord, Lordship had heard the matter yesterday, my Lord.
Yes, I thought that I'll sit up to 4:45, but there is some meeting and meeting. Yes, I think full court and I think some bar also. Bar and bench. I've been informed. Vehicle custody.
My Lord. This search sheet matter, my Lord, on the stage of evidence, my Lord.
I am not concerned with that. I am concerned with
My
clock.
Lord, I'm extremely sorry.
কি করা যায়? Cattle.
My
Cattle
Lord.
issue.
Cattle issue, my Lord. I've been not named in the FIR, my Lord, neither I have been named in the search sheet, my Lord.
Friday, Friday. I thought that today I'll give, but not possible. Friday.
My
Mr.
RB Guha, my Lord.
R.B. Guhai. Land Council for the petitioner, MP Goswami. Land edition, public prosecutor for the response state at present. As there is positive time, let the case be listed on Friday. Last line to repeat করে দিব, huh? And then never will be made to give. Huh? Iman?
Meet PJ Lordship.
Yes, sir.
My Lord, notice was issued to respond number 2 here, Lordship.
Served or not?
Answer, your Lordship may kindly produce operation dated 18th of August 25. It is awaited, your Lordship.
So how to get it served?
The Lordship may kindly allow us to take steps to waive the justice service, Lordship.
1 minute. Your conviction is under?
468, Lordship.
Huh? Conviction, where is the judgment?
Page 38, Lordship, Annexure 4.
Page?
Conviction, trial court judgment is at page 22, Lordship, Annexure 3.
Page?
Page 22, Lordship.
22, trial court judgment?
Yes, Lordship. Against that, we have SAL, we have
1 minute, where is the operative part?
22, page 36.
Conviction is for what?
Page 34, Lordship.
468.
Yes, Lordship.
Then what has the appellate court found?
It was, the order of conviction was set aside, Your Lordship.
Huh?
At page 38, Lordship, Annexure 4. Operative part is at page.
You are the accused, who is the petitioner? Anupama Soliha.
And
Anupama Soliha. She was accused before the trial court, right?
Lordship.
She was accused before the trial court.
Lordship.
Then conviction.
Conviction, Lordship.
Under section 468.
Lordship.
Right. Then criminal appeal. Criminal appeal. Huh. It has been set aside.
Lordship, but Lordship, kindly come to page number 45. Further, the case was remanded back, Your Lordship, by the appellate court. On the same ground on which was.
Paragraph 11.
Yes, Lordship, 11.
Then notice is to be served.
Lordship,
You are acquitted, still you are aggrieved, acquitted and remanded back.
Lordship. Lordship may allow us to take steps to justice service.
Call for the trial.
If the court is here, Lordship. Yes, sir.
So the trial is stalled.
Right.
After remand,
Yes, Lordship.
trial was to proceed
Yes, Lordship.
because of the TCR.
Lordship.
PSA got called for.
Lordship.
Yes, PSA court has been called for, meaning thereby it is impliedly stayed
Lordship.
without passing any order on merit.
Lord.
Earlier that was the practice, no
Earlier.
interim order, but LCR called for everything
Then again,
finished. Now there has been after that scan copy. Who is the respondent number 2?
At page 2, Your Lordship.
Harpal Singh Puri. Address is very specific otherwise.
Yes, Lordship. In fact, Lordship, we have information, he has received the notice. In fact, we have information that he has received the notice.
But no record.
Lordship, that is the issue.
Mr.
S.A. Riaz, Lordship.
Yes. For the petitioner and Mr. MP Gusami, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, are present. Perusta. Office notes dated 1/5/2025. Full stop. As the notice has not, as no report, as regards service of notice. The respondent number 2 has been received. Comma. Mr. Swenso, Land Counsel for the petitioner, submitted that the petitioner will take first steps for service of notice at the correct and proper address of the respondent number 2. Full stop. As prayed for, comma, the petitioner is permitted to take steps for service of notice upon the first steps for service of notice upon the respondent number 2 by registered with AD as well as the usual process. Within 2 working days, at the respondent number 2's correct and proper address within 3 working days from today is the case of the courts.
Lordship, yeah. Justice may be allowed, Lordship.
Criminal case, Rosti.
Lordship, if you oblige.
May it please your lordship. Here also, my lord, service not completed, my lord. We have attempted.
What is the case about some?
Here, my lord,
This is condonation of delay.
Condonation of delay, my lord. The IA is for condonation of delay.
236 days.
236 days.
For why you have preferred the appeal?
No, actually, my lord, the trial proceeded, my lord. And my lord,
And conviction.
no, my lord, appeal against acquittal, my lord. The
Appeal against the acquittal, then it has to be solved.
lordship. It has to, but my lord, we have tried.
Had it been your conviction, I could have allowed it.
Lordship. It has to be served, my lord. But we have taken steps, my lord.
For what offense?
My lord, offences are, my lord, here, my lord, 448, 354, 379 theft, my lord, house trespass, criminal intimidation.
It is bona fide prosecution or persecution?
No, prosecution.
S.M. A. Abdullah for the applicant. MP Goswami for the opposite party number 1 from the state of Assam. আগৰ permission লিখি দিব as no report as the service of function, আগৰ permission লিখি দিব registered copy.
My lord,
Steps.
steps, my lord. We have taken, for the fourth time we have taken, my lord, that
What to do?
lordship is correct, my lord. We cannot take
What to
Dasti
do?
also because criminal
He
case.
has to be served because he has required a right by getting an order of acquittal from the trial court.
Lordship. No,
He
no, it
has to be served.
Not, but Dasti cannot be served, my lord.
Dusty criminal proceeding I don't allow.
Lordship. Oblige your lordship.
Many things can happen.
Lordship.
Next.
Item 33.
May it pleases your lordship.
Yes.
The lordship by the office note dated 18/8/2025, neither AD card nor answer notice nor any service report in respect of the respondent number 2 has been received back by the section till date, upon whom notices were issued by registered post with AD and through the district magistrate Borpeta on 7/1/2025 respectively. So
What to do?
TR has been received. TCR has been received.
What is the case about?
The case, we are challenging a particular order of the trial court by which the petition filed by the father of the petitioner, claiming that the petitioner was a juvenile on the date of occurrence of the incident. He was a juvenile and he must be considered as a CCL, that is child in conflict with law. That petition was rejected only for the difference in surname of the petitioner in the court records and in the certificates that have been exhibited therein. 2 certificates have been exhibited. One is of
Who is respondent number 2?
respondent number 2. She is the informant. She is the mother of the victim.
She can definitely throw light. But Mr.
A.I. Ahmed.
A.I. Ahmed learned counsel for the petitioners and petitioner. How many? 1 or 2? Petitioner.
Petitioner only
MP
1.
Goswami. 1. Perust. The office note. Dated 26/2025. Await for the service report in respect of the respondent number 2. Lays the case after 2 weeks. Trial is going on. Trial
is going on tomorrow. The date is fixed for arguments. Is the problem. Arguments. That is the problem. If a date may be fixed.
Plea of juvenility can be taken up to Supreme Court, no problem.
That can be taken even if that a date may be fixed. Can be.
Don't make this court relegating to the registry.
Deeply obliged.
If I find a fit case, I fix.
Deeply obliged.
Item 34.
May it please lordship? Lordship,
Yes.
as per office letter 18/8/25, service report is awaited and LCR is also not has been received.
Okay. MS. MS.
Sorry, Lordship, Elcher received.
MS.
D Pathak.
D part of D for Delhi. Petition. Mr. Goswami. For the respond number 1 from the state of Assam. Peruse the office note dated 8/8/2025. PC has been received. Await for the service report in respect of respond number 2. Release the case after 2 weeks on a date to be fixed by the office. Education will be
35.
Legal Lordship. Well, as per office note, my lord, perhaps the service is completed against the private respondent. No?
Received. Received.
Yes. Only the other mode, my lord, through the trial court, my lord, that is pending.
Yes. Itu doesn't need flag X. Itu supplementary file to supplement. Part 2 file. Art Mr. R. Chakravarti, Land Council for the petition. And Mr. M.P. Goswami, Land Edition, R. Kosik, Land Edition, Public Prosecutor to the respond number 2. State of Assam, Oslo, as per office note dated 18/8/2025, the notice sent by registered post with AD has been duly served upon the respondent number 1 as reflected, as it is reflected that in the ID card, as the signature of the respondent number 1 as the recipient is reflected in the AD card received after service. As the service upon the respondent number 1 is found, is deemed, is found to be complete, release the case in the admission column after a week, on a date to be fixed by the office.
The trial court, the matter is fixed up 26th, my lord. I had an interim prayer, my lord.
Next admission.
Item 36.
May it please, Your
Lord, neither the AD card nor the service report has come, my lord. The informant, my lord, he is the resident of Beltola.
Beltola.
My lordship. Actually, the matter is, my lord, 138. A check was issued, then it was not, my lord, it was dishonored. And then 406-420 case was filed, my lord. That is why we have come under section 482.
MK Das, what to do? We have
My lord,
to
I will
wait.
take press steps, my lord, press steps of notice,
Okay,
my lord.
MK Das petitioner. RR Kosik. Respondent number 1. Peruse the office note dated 18/8/2025. Mr. Das, Land Council for petition has submitted that the petition be granted opportunity to take first steps for service of notice upon the respondent number 2 by post office. As sought for the petition shall, the prayer is allowed, the petition shall take steps for service of notice upon the respondent number 2 by registered post with AD as well as by usual process at his correct and proper address within 3 working days from today.
Lord, this is a commercial.
4 weeks.
This is a commercial transaction, my lord. There is possibility of amicable settlement also. My lord, may I pray for Dasti, my lord, under that circumstances, because if the opposite side appears, my lord, then in the My lord, arbitration.
Okay, yes, let us, but I may not go by Dusty. If he appears in response to Dusty, okay, I'll accept.
My lord.
Right?
My lord.
If he comes to the council.
My lord.
But that you file an affidavit service,
My lord.
that I'll not treat if he doesn't
lord.
appear.
My lord. Deeply obliged.
Okay, Dusty, take it.
Obliged.
37.
Leave.
Against this, the judgment, my lord, the acquittal, my lord, this victim has filed this appeal. Against the acquittal, my lord. The victim has filed this appeal, my lord.
Victim
And-
has filed this appeal.
Lordship, the wife.
Is any leave required?
Leave petition.
Perhaps when victim file, leave is not required.
Are you a victim?
Yes, I'm.
You
I'm
were
victim.
informed?
Subsequently, I have been told that this leave is not necessary. Lordship made this
Not
one.
necessary.
Not necessary.
not
We'll
necessary.
close this.
Yes.
We'll close this. We'll say that registry will register the accompanying criminal.
So registry, my lord, after filing, it was found that it is not necessary. Then
We are observing.
yes. So yeah, yes,
We are observing. I don't think leave is necessary.
not necessary.
Provided she is the victim
Yes, ma'am.
or informant.
Informant.
Let us see the judgment.
She is the wife and informant.
Informant Kamaya Devi.
Can
The informant, man.
she's
Kanmaya Devi,
Lordship.
6% and was treated sorted her husband. He died or what?
He subsequently died.
He died. So victim.
Yes,
I don't think leave is required.
Lordship.
413. Let us see. There is no mention of leave.
Yes, ma'am.
Heard Mr. B. Chetri. Huh? And Mr. R. Kaushik, counsel for the opposite party number 1, comma, State of Assam. Post of the instant application is preferred under section 419 Bharatiya Nagorik Surakha Honita and or stroke section 378 4, comma, Code of Criminal Procedure 1973 for grant of special leave to prefer an appeal against a judgment dated 16/6/2025 passed by the Court of
Additional Session Judge FTC Sonitpur.
Additional Session Judge FTC Hunitpur, Tejpur, Trial Court in Sessions Case Number 87/2020. Post stop. The accompanying criminal appeals is preferred under section 413 of the BNSS. Full stop. From the judgment dated 16/6/2025, it transfers that the applicant as the informant lodged a first information report before Pratejpur Police Station on 13/1/1993, alleging against the accused person with the allegation that the accused persons shot at her husband and as a result of the injuries sustained, her husband died. Full stop. The case was registered as Tezpur Police Station, case number 31/1993, under sections 447, 326, 506, 34 IPC. When it was added, full stop, later on, comma, charge was submitted with under sections 447, 302/34 IPC rate with section 25 within bracket 1 within bracket small a stroke 27 stroke 27 within bracket 3 Arms Act. Full stop. Charges were framed also under the said offenses. Full stop. However, by the judgment, an order dated 16/6/2025, all the 4 charge-sheeted accused persons were acquitted from the charges, resulting in their acquittal. Full stop. The petitioner applicant as the appellant is clearly a victim covered, defined within the definition of section 2 Y. Full stop. The victim of an offense has the right to prepare an appeal under the proviso to section 419 BNSS, which is perimeter to section 372 and the proviso thereto of section 372 CrPC and the proviso thereto. Full stop. Full stop. The provisions of section 413 paragraph 7 to লিখি দিব 8 to লিখি দিব 8 or last দিব comma দি which the applicant has already preferred. Nine to নালাগে. As no leave is required for preparing the accompanying criminal appeal, this leave petition is closed and the registry is to register the accompanying criminal appeal. And thereafter to list the same for admission. Yes, anything urgent here? 39 to this. Roman.
My lord,
Yes.
earlier occasion, my lord, the honorable court issued notice to the resident number 2. I have taken a step, but service is not completed, my lord, as into the.
Okay. As Roman petitioner, RR Kosik. 1. Perused the office notes. Dated 18/8/2025. Await for the service report. Release the case after 2 weeks on a date to be fixed by the office.
All right.
Yes.
My lord, in this notice was issued and
On which case?
PP was there, 40, my lord, 40.
40.
Petitioner behind the bar, conviction is for 3 years, my lord,
Or
3 years.
3 years.
My lord.
And conviction?
Conviction under section 8 of POCSO.
Sentence?
Sentence 3 years,
Sentence 3 years.
my lord.
Yes.
Steps taken and
My lord,
directed to
tomorrow or day after tomorrow, I will take.
You get the service report.
Fine. Further service
Otherwise,
report.
you'll proceed to consider the IA.
Fine.
Heard Mr. Kiyu Ahmed, learned counsel for the applicant. You have IA?
I am, my lord. 749.
Appellant stroke applicant করে দিব আৰু RR Kosik. Respondent number opposite, respondent number 1 stroke opposite party number 1. Post. Notice was directed on 11/8/2025. And a learned additional public prosecutor was to obtain a report from the officer in charge Udalguri Police Station. Mr. Kosik has submitted that he needs some time to obtain a report as regards service of notice among the respondent number 2, opposite party number 2. As the
Office note, my lord, 18/8.
Lordship, here one thing is there, when the order was issued on 11/8. It will go through registered post, my lord. Is too short a time between 11/8 and 18/8 for registered post, my lord.
learned addition was obtained 11/8. Today is what?
Today is 19, my lord.
How it has come?
I don't know.
Because a
But
very short
it
time,
is in the cause list.
11/8/2025.
Yes, ma'am.
How it has come?
My lord,
Because returnable in 4 weeks.
Yes, my lord. Office note, my lord, is there. It is after receiving information, PP directed
Okay,
to.
put a date, another date, get an instruction.
yes, because of what the
4
issue is
weeks.
that, my lord, they will take
I-
step through us, then it
I
will go
don't-
through registered. Registered post, my lord.
Item number 40.
40, my lord.
With office no. By order.
I have not any communication with the.
Mr. Ahmed,
My lord.
don't make wrong submission. Release the case after 4 weeks. You missed the bus.
May I please, Your Lordship, in respect of item number 41.
Item number?
41, Lordship.
Yes, sir.
Yes, Lordship, respondent number 2, service in respect of respondent number 2 has been completed.
What are the offenses?
Lordship, POCSO Act under section.
POCSO. 41.
There is there is a report from the
Service.
investigating officer.
Service.
In the second file, Your Lordship will find there.
19/6.
His office note does not say it, but in the second file, Your Lordship will find.
Officer in charge.
Yes, there is a.
Yes.
Office note.
Criminal appeal.
Yes. Flag Z or something like that, Lordship. It is flagged.
Service is complete.
Yes, because
9/6/2025 report from the investigating officer. It says that he had delivered it to the informant.
Mr. Arbora,
Arbora.
counsel for the applicant. Appellant.
Appellants, Lordship, 3 appellants.
It has been admitted or what? How much is the period?
Lordship, 10 years.
Okay, we may have to appoint, okay.
Amicus, Lordship.
Admit. Okay, Arbora, learned counsel for the appellants. How many?
3 appellants.
Appellants and Mr. R. Kaushik, learned additional public prosecutor for the respondent state. Poster. From the report of the officer in charge, Tokmoka Police Station, as per the report, the notice has been duly served upon the respondent number 2. Poster. On in June. On report dated করে দিব report dated 9/6/2022, as none has appeared to represent the respondent number 2 till date, this court deems it fit and proper to appoint name one to represent the respondent number 2 in this appeal. Lays the appeal on so and so that reflecting the name of so and so.
My lord, we'll file objection. 10 years conviction, we'll file objection.
File. We have not issued notice, perhaps. Let us have it after 7 days with the name reflected of the amicus. Name one.
1st September.
So I'm sorry, I was looking at you at 2 o'clock. Could not find you.
No.
To inform.
I had a start in court number. I'm also sorry.
Total of Saipela, Khali Jagarat Divosun. Khali Jagarat because.
I am also sorry, Miller. I could not because I was.
I was looking for you at 2 o'clock.
Could
not find you.
I was.
Either Mr. Visas also that I had to rise. Now I'm already late.
Lordship, kindly 43. He is a paralysis patient. Lordship,
Yes,
since 6 days, I've been waiting for that, Lordship. In the meantime, police.
Madam.
Only Lordship.
Next.
No, Lordship, 22 the next date, Lordship. Police has come to the house of the person, Lordship. Only interim prayer may be considered thereafter. Main case may be taken on Friday, Lordship. I don't have any problem on that day. Only that non-believable word and suddenly we issued by the learned magistrate, Lordship, without perusal all the materials. I will show, Lordship, only for 2 days. Only for 2 days, Lordship, thereafter, Lordship, kindly maybe dispose of that.
Take up your case at 10:30 today. 10:30 today. If you are, I have some insurmountable problem. Otherwise,
Give me protection for that only.
I don't give protection without looking at a file. So 10:30 tomorrow. I'll take up your criminal petition itself.
No, Lordship, tomorrow I will be out of station. That is why I am.
No, that everything is not shall not go according to you.
No,
something
Lordship,
has to go because I haven't.
Then my matter may be released, Lordship. It is not possible because 6 days. I have been waiting for that and praying.
Okay, release the case before any other bench without me.
6 days, Lordship. Otherwise, I